What is the deviation?
My lord, deviation has not been, my lord, as of now, my lord, has not been scrutinized, my lord. There is a G+4 sanction plan, my lord. According to the sanction plan, the developer developed the construction, my lord. After that, my lord, they have allotted the portion in favor of the landowners, my lord. And subsequently, my lord, when they have allocated the portion of the landlord, my lord, we have found that there is some certain deviations, my lord. And for regularization of the same, my lord.
After inspection, if it is seen, a deviation cannot be considered. After inspection.
After inspection, my lord, if it is.
Because after the inspection, it will be decided if
My lord.
My lord, kindly come to page 219. My listing আছে সবসময়।
But then, if this deviation cannot be regularized, then they will take for removal of the deviation.
Pardon, my lord.
If this deviation, what you have done,
My lord.
cannot be regularized under his rule,
My lord.
then they will take steps in accordance with law for
My
removal
lord.
of the deviation.
My lord, I do not have any objection to the same, my lord. Let the representation, my lord, be considered and they will take necessary action against the same, my lord.
After inspection.
After inspection.
Ashwin?
My lord, only one humble submission, my lord. I made a mistake in the prayer, my lord. Kindly, if your lordship be kind to come to page number 17. I have specifically mentioned that the respondent number 3 and 4, my lord, that has to be respondent number 2 and 3, my lord.
2 and 3.
2 and 3, my
On
lord.
the prayer of learned advocate for the petitioner, leave is granted to correct the nomenclature of respondent in prayer A of the writ petition. Affidavit of service.
My lord, affidavit of service.
Affidavit of service filed on behalf of the petitioner is taken on record. It's E.
May I hand over, my lord, Rule 15, my lord? I have the copy of the same, my lord.
Rule 15 of
Rule 15 of, my lord, Howrah Jilla Parishad Bylaws 2005, my lord.
the by the present writ petition, the petitioner seeks direction upon the respondent authority, specifically respondent number 2 and 3, to consider the representation of the petitioner dated 16th May 2025 for the regularization of the construction in view of Regulation 15 of the Howrah Jila Parishad Bylaws 2005 with amendment of 2019. The construction turn within bracket G+4 করবেন at LR দাগ number 3403 bracket corresponding to LR Khutian number 95975237644 7645 7647 7648 jail number 28 Mouja Mahiari police station Dongju district Howrah. Petitioner is the flat owner or developer?
Petitioner number my lord, petitioner number 1 to 6 are the landowners, my lord. Petitioner number 7 is the developer.
The petition number 1 to 5 are the
My lord, 1 to 6, my lord.
1 to 6 are the owners of the land comprised within with the tag number such as such. The petition number 1 to 6 petition number 6 did not execute the
My lord,
development agreement.
My lord, petitioner number 6 subsequently, my lord, executed the development agreement. Because, my lord, when the petitioner number 1 to 5 executed the development agreement, at that point of time, petitioner number 6 was a minor.
This you have stated.
I have stated, my lord. I have stated and I have annexed the development
1 to
registered
6
development
executed development agreement with petition number 7 for development of the property. The developer, namely petition number 7, has constructed G+4 commercial cum residential building over the property in question. However, there are certain deviations in such construction. The petitioner approached the Howrah Jila Parishad, respondent numbers 2 and 3.
Respondent number 2 and 3, ma'am.
3 for regularization of such deviation by representation dated
My lord, page number 214. The date is not there, my lord, but it was received by Howrah Jila Parishad on 16th of May 2025.
Since no steps has been taken for regularization in terms of regulation 15 of the Howrah Jila Parishad rules, the petitioner has preferred the present writ petition. Learned advocates for the petitioner as well as Howrah Jila Parishad and state submits that matter be relegated to the Howrah Jila Parishad for causing inquiry and dispose of the representation of the petition. Who will consider this representation?
My lord, Howrah Jilla Parishad, my lord.
Not Howrah Jilla Parishad. Howrah Jilla Parishad will appoint an officer to
District engineer, my lord.
district engineer.
District engineer.
But it will be made in accordance with 160 capital A of the West Bengal Panchayat Act. No? The writ petition is disposed of directing the Howrah Jilla Parishad to appoint an hearing officer under section 160A who shall consider and dispose of the representation of the petitioner dated 16th May in accordance with law after causing inquiry points go the other way within a period of 2 months. In the event it is found that such deviation can be regularized under the existing rules, the Howrah Jilla Parishad will take steps, or otherwise it shall proceed in accordance with 160A of the West Bengal Panchayat of 1973.
Grateful.
Therefore, said direction can be put.
My lord.
Give
May
me photocopy of this rule.
I shall, my lord, I shall.
এই থাকবে 160 এটা করবেন 160 ক্যাপিটাল আমার একটা করা আছে আপনি পাঠান আমি এটা বার করে রাখছি হাওড়া জেলা পরিষদ হলে ওদের একটা স্টেটের হিয়ারিং এর
ফোন নেবে
অফিসারকে অ্যাপয়েন্ট করে যে হিয়ারিং এখানে যে প্রধান আছে ওখানে একটা অফিসার থাকে অ্যাজ পার এটা করা আছে আমার
রাহুল কোথায়? একটা পক্ষ ম্যাটার
করবেন 160 এতেই করবেন
বিদিশানা
যেমন হাওড়া জেলা পরিষদ 160 ওটা হলো 23
my lord, the affidavit of service is with me.
which item
25.
25 দাও নেব ঠিক আছে পার্টিজ এসছে
I am happy for the only private option number 9.
25 নেবেন বলুন।
But there's a matter fixed on 12:30.
12:30 minute দাও 7
I'm for the effect of
my lord, the affidavit of
My lord, in this matter, my lord, I am seeking for a consideration of the representation.
Only this one, number 9.
Private respondent. Pradhan again. Other respondents you are not representing. Only 9. Zero.
Nidish.
Seven not served. Respondent number 7 not served.
My lord, one has refused service.
Who is he?
Anjana Maiti.
Anjana Maiti is refused. Anjana Maiti has been delivered.
No, my lord, Anjana Maiti has refused service. Respondent number 7 is Anjali Shah.
Anjana is.
Anjana Maiti is respondent 8.
Okay, it's no. About 7.
And with respondent number 7, my lord, she used to work at Egra Hospital. That was my last known address. I've served it at her workplace, but then she is not working there anymore.
Okay. What is her residential address?
My lord, I'm not aware because I'm not in touch with her. That was her last known address to me.
Okay.
Though they are not the answering respondents, my lord, the state shall consider my representation. That's at page number 53 over a stretch of land. My lord, a multi-storied building has been constructed. The Pradhan will consider my representation.
What is your grievance?
My lord, the grievance is that they have constructed a building and that too over a patch of land which is mine. My lord, the building is absolutely unauthorized. They did not obtain a sanction plan. I've placed an RTI before the Pradhan. The Pradhan did not reply to it. My lord, my representation is at page number 53.
Not constated.
Because respondent number 9 is not staying there. They have been made a party only as a legal heir to the property.
State.
Nothing. Pradhan is the appropriate authority. No, nothing.
Respondent number 9 is not staying over the property, but then is the legal heir of the property for which they have been made
By the
respondents.
present writ petition, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the
Respondent number 4 is the person
direction upon-
constructing.
Respondent number?
Respondent number 4 is the person constructing.
Pradhan.
Competent authority is Pradhan. Respondent number 4.
Respondent authority is to consider the representation of the petitioner dated 30th January 2025. The petitioner contains alleges of unauthorized construction undertaken at the instance of the private respondents. Learned advocate for the which is the plot?
My lord, plot it's page number 53. My lord, kindly comes to
Plot number
plot number 3859, Khatiyan number 1846.
by the private respondents over plot number 3859. Tailor Khatiyan number 1846, jail number 203, Mouja Pani Paru, Agra. Learned advocate for the petitioner as well as state submits that the matter be relegated to Pradhan to cause inquiry. Learned advocate private respondent number 9 submits that his client has not made any construction over the property in question. Upon hearing the learned advocate for respective parties, Pradhan is directed to and he denies and disputes the allegation. Yes.
my lord, subject to correction, the plot will be 3849.
3849.
49.
ওটা হ্যাঁ ওখানে যেখানে কজ অ্যান্ড ইনকোয়ারি যেটা আছে ওখানে প্লট নাম্বারটা বলবে 3849 হ্যাঁ there is a mistake in your representation.
Yes, sir. That may not be that may be corrected through this order.
The cause inquiry in respect of plot number 3849. প্রপার্টি স্পেসিফিকেশন ওখান থেকে তুলে ওখানে দিয়ে দিও অসুবিধা কি আছে ডিসপোজ
My lord, may I kindly frame a timeline within
2 months.
Grateful. Much obliged.
Lord, I appear on behalf of the petitioner. Lord, the subject matter. Lord, the subject matter, my lord, relates to Lord, illegality, arbitrariness, inequality, and bias at the behest of the respondents number 227 in respect of tenders under the Panchayat and rural development. Lord, on 31st of January 25.
Who is representing this?
I'm appearing for respondent number 8, the private respondent. He has alleged that in favor of my client, work order has been issued and he has sought for cancellation. Fact remains, this is absolutely frivolous writ petition. This petitioner himself is a blacklisted candidate.
I don't think that maintainability is being raised. Will not kindly permit me to place my case.
Has not been given any work order, and his prayer is for cancellation of work order in favor of the respondent number 8.
Yes. Now, Lord, kindly, my Lord, sees, my Lord, page 29. Lord, this is, my Lord, the tender inviting notice. Page 29. This is, my Lord, in respect of, my Lord, kindly sees Paschim Mednipur, Panchayat and Rural Development Department, Government of West Bengal, Mednipur Circle. My Lord, kindly, my Lord, sees page 33. I am invoking, Lord, the clause 5 of this NIT, which says submission of original documents. Only L1 bidder is required to submit original affidavit regarding correctness of information furnished with bid documents as per provisions of clause so and so to the executive engineer by hand within 7 days from the date of issue of letter of acceptance of the bid. These documents must match. This is important. The scanned copies submitted with the bids online. In case of any deficiency in this respect, it will be treated as misrepresentation by such bidder. Such a bidder shall be liable to be debarred from participating in bids under so and so for 5 years. Milord, I participated in this selection process. My documents were, Milord, found to be insufficient. Milord, I was, Milord, blacklisted for a period of 1 year. I have stated that in paragraph 5. Now, Milord, I made complaints in respect of the respondent number 8, who, Milord, was successful. Milord, kindly comes to, Milord, page 57. Milord, this is my complaint that even yes, this is, Milord, made by the private respondent number 9, Milord, who has given the infrastructural facilities, Milord, on lease to the respondent number 8. Kindly sees what is a complaint. It has come to my knowledge through so and so that Manbhum Construction, Milord, my learned friends, Milord, clients, has submitted a bid for package number so and so using an agreement that is false, fabricated, and manufactured. Milord, kindly now, Milord, comes to the next page, that is a reminder, and in terms thereof,
Yes.
page 59, Milord, the respondent number 9, whose bid was accepted, my lord would kindly find on page 59, serial number 2, the name is Manbhum Construction, and the status is accepted, and then L1. My lord has very kindly found it, my lord. In view of the complaints that I and the respondent number 9 make, my lord, this, my lord, was cancelled. My lord would kindly come to page 67. 66, I'm sorry. As complaint received against bidder, namely the respondent number 8, the matter has been discussed as per 49th meeting of the department tender committee. Participant qualifier bidder of the aforesaid work, namely Mr. So-and-so, marked as not qualified due to improper credential certificate. So, technical revocation of the above tender is required. Kindly comes to the next page. Blood kindly comes to now page 68.
66 and 67 are same.
Same. Kindly come to page 68.
Yes.
This is, my lord, the decision of the tender, departmental tender committee. My lord, this is held on the 7th May 2025. Now, my lord, kindly sees that the second paragraph. Thereafter, as per prevailing norms, after receiving AOT of the executive engineer, Purulia division has verified the original documents of Manbhum construction. On verification of relevant credentials, certificate of the bidder, the executive engineer found some discrepancy in respect of the bidder's subcontracting credential as well as the prime contractor credential. The matter of such discrepancy mismatch in respect of credential certificate has been forwarded by the superintending engineer Mednipur Circle to the department committee, and it was discussed in DTC in its 51st meeting held on 7th May 2025. Now, after discussion, the departmental tender committee in its 51st meeting held on unanimously recommends to cancel the accept of tender AOT on the ground of improper credential certificate of the respondent number 8 while doing original verification of the executive engineer. The DTC also recommends to cancel the tender bearing number so and so and decided to invite blood afresh.
They have found the discrepancy.
Now, discrepancy is found. My lord, I take my lord again, my lord, back to page 33. But at the risk of repetition, I invite my lord's kind attention to clause 5, the last 3 lines starting with the words, in case of any deficiency in this respect, it will be treated as misrepresentation of such bidder. Such bidder shall be liable to be debarred from participating in bids. Now, they cancel this, but they do not debar him for the period, my lord, of 5 years. In respect of the petitioner, my lord, although they have taken such action, my lord, this debarment, my lord, has not been challenged by the respondent number 8. So he accepts this. But now, my lord, kindly sees he has been.
Not debarment. It is deficiency has not been challenged. He has not been debarred as yet.
No, that is what I'm saying. He has not been debarred.
No, you says that he has not challenged the debar.
No.
The debarred order that has not been passed.
That has not been passed, which should have been passed.
The deficiency has
he accepted it. So the debarment should have come. He accepts the deficiency, so the debarment should have come. Instead of that, my lord kindly sees, in respect of Purulia Circle, my lord, a tender notice is issued. Kindly sees page 69. And kindly sees, my lord, page 70, the respondent number 8, my lord, is awarded with this tender. Kindly see serial number 4. The same respondent number 8. And he uses the same credentials. He uses the same infrastructural documents of the respondent number 9. But
this is in respect of some other work or the same work?
No, another circle.
Another circle.
Another circle. But that was Mednipur Circle, and page 69 is Purulia Circle. But it is under the same Pradhan Mantri Gramin Yojana. And at page 33, I showed to my lord that the concerned person would be blacklisted for 5 years in respect of any scheme under the Pradhan Mantri Gramin Yojana. Now this
be limited to Mednipur Circle.
No. 33 kindly
under the PMGSY.
Yes. And that this is also under the same Yojana. Kindly sees page 76. My lord would very kindly find left hand side top.
Yes.
My lord would find that this is for Pradhan Mantri Gramin Sadak Yojana. My lord has very kindly got it. And then kindly sees, my lord, the second block, corporate tender details, my lord, the name of the respondent number 8, Manbhum Construction.
was the 16th meeting. 16th. Deletion of tender committee was 7th.
And kindly see, my lord, the date on the right hand side top, 16th May 25. After, my lord, he has been found to be in deficiency in the meeting of another circle, my lord, on the 7th of May, which I showed to my lord. But in respect of this, my lord, the petitioner, my lord, made complaints. My lord would very kindly find that. Let's page 79. Page 79.
Just a minute.
I'm sorry. Page 79 and 80 are the representation to Mednipur Circle saying that kindly blacklist him for 1 year like you have done in respect of the other tenderers whose deficiency have been found. That is page 79 and 80. And at page 81, I have made representation to the Purulia division saying, Lord, that kindly cancel this because he is using the same credentials based on which the other tender in the other circle has been cancelled.
Circle is one.
Division, I'm sorry, the other division. It's the circle is same.
How? Medinipur division or Purulia division?
Mednipur circle under Purulia.
Mednipur circle is under Purulia division.
Huh? Purulia division is under Mednipur circle.
Purulia
circle, my lord, has 3 districts: Mednipur, Bankura, and my lord Purulia.
Superintendent engineer actor. Either under executive engineer Putra division.
Now the superintendent engineer is one.
Comes under Mednipur circle.
Yes. Now, my lord, kindly see by letter demanding justice at page 82. I have made this letter demanding justice on 1st of April 25 to the superintending engineer. And, my lord, I have narrated, my lord, the entire, my lord, grievance. Now, kindly comes to, my lord, page 83. My above named client has lodged multiple complaints regarding fraudulent machinery documents submitted by Manboom Construction in relation to following packages. Now, these are, my lord, the same packages which have been utilized, relied upon by the respondent number 8 in respect of, my lord, the first tender, which is, my lord, at page 33, I showed to my lord. If that has been found to be deficient and a misrepresentation, then one, that he should have been blacklisted in that, should not have been permitted to participate in the second one.
But then this third one is not there.
The third one?
Package number WB 16752.
That is
respondent.
Yes, but the other two are there.
The respondent is Mr. Ganguly's client.
No, I'm for respondent number 9. My lord, who's my lord document report? It is going on, my lord. Can take this, my lord. The respondent number 8's candidature was cancelled. The documents which he has relied my documents, which I say I have never, my lord, trusted the respondent number 8 from using those documents. Now, preparing those false documents, my lord, he has procured. Well, he tried to procure the initial first tender, my lord, from the Mednipur, from the division.
Mednipur circle.
So in your letter at page 57,
yes,
these two packages there, 750 and 741.
Yes, package number 16741.
As far as the third is concerned, where is the document?
752.
752.
Page 64.
64, my lord.
64.
Page 64.
After decision of the tender committee or
Kindly see page 64, serial number 3.
Yes.
And the tender reference is 16752.
Yes.
Due to improper credential certificate, the respondents number 8. It was rejected.
as per the decision of the
Rely, my lord, on my lord, the decision. To Devan, please. 8 again. This is reported in 2004, volume 3, Supreme Court cases, page 553. Lord, kindly, my lord, comes to Lord, paragraph 8. As could be seen from the argument addressed in this appeal and as also from the divergent views of two courts below, one question that falls for consideration whether a writ petition under Article 226 Constitution is maintainable to enforce contractual obligations of the state or its instrumentality. And this, Lord, is answered. My lord would kindly come to page 570, paragraph 23. It is clear. It is clear from the above observations of this court. Once the state or an instrumentality of the state is a party to a contract, it has an obligation in law to act fairly, justly, and reasonably, which is a requirement of Article 14 of the Constitution of India. While
which paragraph of this judgment the Tata Cellular has been quoted?
Tata Cellular, my lord,
Legal principles, if any,
may I indicate
the interest or instrumental state rather contraction merely because some dispute of the facts arise. If you get written in the concept.
টাটা সেলুলার এখানে কি রেফার্ড হয়েছিল?
Not referred.
But just a second. So I do not find, my lord, that Tata Cellular, my lord, has been, and this, my lord, ABL, my lord, has been relied by the Honorable Supreme Court with approval, my lord, in a very recent decision, which is, my lord, Subodh Kumar Singh Rathore. Devan, please. This is 2024 SCC Online SC 1682. Lord, I rely first, my lord, on paragraph 54. The law on the subject with which we are dealing was laid down exhaustively by this court in the decision in Joshi Technologies International. Now, Lord, kindly sees, Lord, turn over the page. Lord, Joshi Technologies, paragraph 70.1. At the stage of entering into a contract, the state acts purely in executive capacity and is bound by the obligations of fairness. But this fairness is, my lord, what, my lord, I, my lord, impugn. That insofar as I am concerned, you debarred me for 1 year. In respect of him, on my complaint, you only cancelled it, but awarded him with another contract in respect of the same circle,
Same documents have been.
wherein the same documents are relied.
Yes.
Then Lord 70.2, state in its executive capacity, even in contractual field, is under obligation to act fairly and cannot practice discrimination. Then Lord 70.7, writ can be issued where there is executive action unsupported by law, or even in respect of a corporation, there is a denial of equality before law or equal protection of law, or if it can be shown that action of public authorities was without giving in hearing violation. I will not only pause here for a moment. If it can be shown, if there is a denial of equality before law or equal protection of law. And Lord kindly, Lord comes to Lord paragraph 55. Lord on page paragraph 56. Lord ABL Millard has been relied upon with approval. And then Millard kindly sees Millard paragraph 63, meaning and true import of arbitrariness of state actions in contractual disputes. And here Millard 79 Supreme Court Millard Ramanna Sethi Millard has been relied upon. Millard I rely on that the last 4 lines. It requires that state action must not be arbitrary, but must be based on some rational and relevant principles, which is non-discriminatory. It must not be guided by any extraneous or irrelevant considerations, because that would be denial of equality. This is, my lord, how, my lord, for decades, my lord, the Honorable Supreme Court has defined, my lord, what is arbitrary. And then, my lord, 65. If there is a prescribed manner and it is deviated upon which yields a benefit in favor of some, then, my lord, it is not fair, then it is an arbitrary action. 65. The meaning and true import of arbitrariness is more easily visualized, precisely stated or defined. The question whether an impugned action is arbitrary or not is ultimately to be answered on the facts and in circumstances of a given case. An obvious test to apply is to see whether there is any discernible principle emerging from the impugned act, and if so, does it satisfy the test of reasonableness, where a mode is prescribed for doing an act and there is no impediment in following that procedure. The performance of the act otherwise and in a manner which does not disclose any discernible principle which is reasonable may itself attract the vice of arbitrariness. But page 33, clause 5, I showed that there was a prescribed procedure and prescribed consequences. There is no reason to not apply it in respect of the petitioner and obviate it to the benefit and in respect of the respondent number 8.
That's one.
Those will not are my respectful submissions.
Yes. Mr. Ganguly.
Yes. Lord, I am appealing for the respondent number 8. Lord, your lordship was searching for the Tata Cellular. If I can recollect from my memory correctly, Tata Cellular, Whirlpool, all are on the basis of the, if there is any violation of fundamental right, alternative remedy is no more. And it is series of judgments that they are on the alternative remedy, that it is not a strict law. It is the judicial pronouncement and discretionary can be issued. I am not on the Malad petition into the alternative. The decision my learned friend has cited, or I have not gone through the all decisions, but as I heard from my learned friend, I accept. I duly accept all the Malad ratio of the decision cited by my learned friend. The state should act Malad fairly. Nobody can urge that no state can act unfairly. I accept. But whether those decisions are applicable in the given case or not. What is the case before Lordship? In short, I am telling you, Lordship, the petitioner was blacklisted. Now, XYZ tender proceeding is going on. In XYZ tender proceeding, my client participated. Whether my client has used these documents, whether these documents are fake or forged or not, whether this document is insufficient and not relevant, those matters are involved. It is the authorities. The authorities taken the decision. The authority taken the decision. What is the decision? Lordship, kindly come to page 68. If I am collecting page number of pages. Yes, my learned pen relied upon 68. I'm reading for your Lordship the last paragraph, last ultimate paragraph. After discussion, may I read?
Yes.
After discussion, the Departmental Tender Committee 2025 in its 51st meeting held on 7th May 2025 anonymously recommends to cancel the accept of tender AOT while doing the AOT on the ground of improper credential certificate of such and such. This is Manbhumi is I am this operator. Now take the note of the improper credential. Now, Lordship, I will draw your Lordship's attention on the page 30. I'm telling you, Lordship, the clause 5, that is at page 33. Page, Lordship, kindly come to page 33. Before I place the portion of the 33, I will draw your Lordship's kind attention to the signatories at page 34. Page 34. Superintending Engineer P&RD Department, Government of West Bengal, PRNMU, Mednipur Circle. My learned friend submitted tried to make out a case that this is the general guideline of the under the Pradhan Mantri Gramin Rojgar Sorok Rojgar Prokalp. That is not correct. It is a condition prescribed by a portion of the authority who are carrying on this project. Now, Lordship, I will read the page, clause 5. There is no case, there is no document that this is the applicable for all over India for this scheme. I could not find out in such. Now, I will read the clause 5 for your Lordship. Submission of original documents. So, the responsibility to submit original documents. Only L1 bidder is required to submit original affidavit regarding correctness of information furnished with bid documents. So, first there will be bid documents. There is a bid with documents. Then, he will be asked to furnish original. As per provisions of clause 4.4b(a) Roman 3 of ITB of Executive Engineer of Concern, West Bengal Social Rural Development Authority Division, in short, by hand with 7 days from the date of issue of letter of acceptance of bid. So I have to, within 7 days after letter of acceptance, I have to submit the original documents to match with the documents I have submitted. Now, these documents must match the scanned copies submitted along with the bids online. Kindly take note. It must match with the bid documents. So, if I submit document X and I produce the document X1, this clause is attracted. Suppose I submitted document Y in the at the time of bidding, and within 7 days I am submitting the same document. If the document is insufficient, then my pair may be cancelled. But if does not match with the documents I have submitted, then only penal commission is coming, even under this clause. Though I am not leaving out my argument that whether this clause was applicable for the particular tender or not, that I could not find out any paper. Now let's kindly see the next question. These documents must match the scanned documents submitted along with the bids online. In case of any deficiency in respect, here is the question. In case of any deficiency in respect, just I have given the example. I have submitted X document, but when I am submitting the original, that document shows X1. If that deficient, it should be mismatch. The word mismatch afterwards it has been caused. It will be treated as misrepresentation by the such bidder. Then such a bidder shall be liable to be debarred for participating in bids under PMGSY Pradhan Mantri Gramin Sadak Yojana for 5 years. So this is the condition my learned friend showed to your lordship. Now what my learned friend is challenging, then for I have to place the prayer of the writ petition. Please kindly come to the prayer of the writ petition. All prayers are lengthy. I am not troubling your lordship. Probably time is over for this. But in this, their main prayer cancel his work order. So, please let me submit. At your time, you will. May I read, Main document is lordship kindly come to the paragraph prayer C. And to fix responsibility upon the authorities, private individual, government department, illegally issuing work order in favor of the private respondent. So they are inviting your lordship to decide, to believe that work order was issued or was being issued. That is absolutely not correct on the face of their document annex. They have shown to all the pages that it was cancelled. Now, what is their next phase of grievance? That he was blacklisted for XYZ reason. Those reasons are not before your lordship. Now, why I should not be blacklisted and equally treated? This is not the equality. You might have been blacklisted for a particular authority for A, B, C, D reason. And I have not been blacklisted till now. I have not been blacklisted. He has submitted that I have not challenged. But not treating my documents as sufficient for getting the work order is I have not challenged. But there is no decision till now. How I will challenge my blacklisted? His pair is that I have been declared blacklisted. So XYZ also should be declared blacklisted. According to him, for the same reason, equality, but no documents he has shown, he has produced that what is the reason for his blacklisting, by which authority. And my lord, being a blacklisted contractor, I will submit before lordship. He has no locus to challenge anything. First, let him satisfy his locus. I am not on locus. I am not maintainability on the question of contractual or not. I am on the question of maintainability of the writ petition by a blacklisted contractor. First, he has to satisfy that he has any locus to challenge. There is a decision, rightly or wrongly, authority has taken a decision. But he has not made out any case that the authority has not done X, Y, Z, A, B, C. Authority should have been done P, L, M. They have not done. Now, no case. His main prayer, I am blacklisted, so other should be blacklisted. Plus, you understand that there is a rival condition between the contractors of the same area. So, this writ petition is absolutely frivolous, not maintainable at all on the face of his apartment.
That's all.
Lordship.
Come back and you make your submission.
But after recess. But after recess, because he has relied upon the judgments, I could not go through those judgments. Though in overall, I am submitting that those judgments are on the basis of the fairness of the state, equality. I am accepting equality should be maintained. But in this case, he could not come up with a prayer that I have been blacklisted, so Ram should be blacklisted. For these, it is not going to.
At 2 o'clock, my lord.
आप तो मेने नहीं लेते बोले तो
loss permission. But I will add one thing. During recess, my lord, I have got some instruction from my client. But the respondent number 9, and the advocate for the respondent number submitted that against me. But the respondent number 9 by his letter, but instructed the authorities that the documents, but he known the respondent number 5 by name, Ashok Pal, and as that later 5758, that his 5758 shown to your lordship, it is clear that he came to know, that respondent came to know through the petitioner.
File to the
57 lordship once comes.
Argument of it.
First line, it has come to my knowledge through Mr. Gautam Pandey, the petitioner. Madhuban construction, such and such. Now, I have got this letter during the recess that this Molai Chatterjee, this from 9, I written this letter. I want to bring this letter on affidavit, my lord. And actually, I am making a submission that his prayer, he is not challenging 68. 60 page 68 decision of the tender committee is not under challenge, but he is making prayer before lordship that his cancellation is not sufficient. He should be debarred. This is the scope of the petition. So,
what is this letter? Now, verification of.
This letter has been written by Molai Chatterjee, respondent number 9, to the authorities and sent it by message in their email. This is my instruction just now I got. So, I want to bring this on the.
What is this happening? Once Mr. Ganguly appeared and they said that on his prayer, your previous one was cancelled.
Yes.
Now, in the subsequent one, he has given this letter.
So I want to use this letter on affidavit. His main prayer, he wants to allow the main prayer at the stage of motion. I must be given an opportunity to contradict on the affidavit.
Where is Mr. Ganguly? He will not file any affidavit in opposition to the writ petition.
I want to file a detailed affidavit.
Affidavit of service, Mr. Ghosh. Affidavit of service filed on behalf of the petition is taken on record. Oh, it is here. Sorry, it is here. Mr. So and so. By the present writ petition, the petitioner seeks for direction upon the respondent authorities, particularly respondent 4627, to blacklist private respondent number 8 to participate in tender process for 5 years under the Pradhan Mantri Gram Sadak Yojana PMGSY and also for fixing responsibilities upon the authorities concerned for illegally issuing work order in favor of private respondent number 8. Mr. So learned advocate for the petitioner submits that the respondent number 8 participated in notice inviting tender in PMGSY-3 batch 1 Roman 3 PMGSY-Roman 3 batch 1 of 24-25 annexure P1 as per clause 5 of the said NIT. In case of any deficiency in respect of the documents furnished by the participating party, it will be treated as misrepresentation by such bidder, and such a bidder shall be liable to be debarred from participating in bids under PMGSY for 5 years. ওখানে একটু এটা মেনশন করে দিন তো, যে এনআইটি বললাম না,
আমার মক্কেল
পিএমজিএসওয়াই
রেসপন্ডেন্টকে একটা চিঠি
মেদিনীপুর
দিয়েছে,
সার্কেল।
লিখে বলেছে যে আমি এই মানভূম কনস্ট্রাকশন, যে তার মালিকের নাম আমি জানতাম না, তার মালিক অশোক পাল, তাকে আমি দিয়েছি। সেটা নাকি দিয়েছে বলছে, বাট there's no stamp ছাপ। বলেছে এটা থ্রু মেসেজ নাকি পাঠিয়েছে, না বায়োফিন এফিডেভিট
On an application by private respondent number
সেটাই কথা।
9,
এফিডেভিট করে রাখছে, এইখানে আবার এফিডেভিট করে আসবে, এটাও এখানে দেখা
the
ডিসাইড হোক।
matter in respect of the bid submitted by private respondent number 8 was inquired by the superintending engineer P&RD department RRNMU Medinipur Circle, and the departmental tender committee unanimously recommended to cancel the accept of tender AOT on the ground of improper credential certificate of respondent number 8 Messrs Manbhum Construction 68। ওর আগে একটু বলে দিন যে the bid of respondent number 8 was accepted, যেখানে ওই মানে রেসপন্ড নাম্বার 9 এর বললাম না কমপ্লেন্ট অফ রেসপন্ড নাম্বার 9, তার ঠিক আগে বলে দিন।
Well, may I get one thing? The cancellation was to this effect that there was discrepancy and mismatch. Kindly come to page 68. It was not on
68, the last portion says that
the
improper
second paragraph, my lord. For miscellaneous item number 1, kindly go to the second paragraph. My lord, may I read for your lordship? Thereafter, as per prevailing norms, after receiving the
credentials.
Please, my lord, taking the case from the behalf of the petitioner, my lord.
Yes, naturally, you are using my documents. My lord,
Here
he
is
is
another
using my documents. My
Another
lord,
We will bring on record this
which one,
document.
my lord? Dekhi.
I'm giving a copy. Your lordship, keep it. I'm giving you a copy. Just a minute,
My lord, this is an undated document, my lord, he is using.
I don't know, he has
Same
produced, we
thing
will be
I said.
filing affidavit.
Leverage.
You find
My
out
lord,
from your
giving a
client whether he has
undated
issued such letter or not.
This was this on affidavit.
So what benefit he will be getting, my lord? I am there, my lord. I am saying, my lord, that it has not been issued by me. Let the department decide this. Whether my lord, department wants to blacklist as per clause 5 or not, my lord, it's the prerogative of the department.
Improper credential certificate. Huh?
My lord,
However, subsequent thereto, the respond number 8 participated in another work under the Purulia division, which comes under the Medinipur circle under PMGSY scheme, and his tender was accepted. The authorities have not acted fairly, while in case of the petitioner, he was blacklisted, whereas the respondent number 8 was allowed to participate in the subsequent tender, although his documents were found to be improper in the earlier bid submitted by him.
Lord, may I take my lord's kind leave, my lord? I'm grateful.
To buttress his contention, he relies on the decision of Honorable Supreme Court passed in ABL International Limited and another versus Export Credit Guarantee Corporation. This he seeks for হ্যাঁ এটা হচ্ছে সুবোধ কুমার সিং রাথোড ভার্সেস চিফ এক্সিকিউটিভ অফিসার এন্ড আদার্স। ছোট করে হয়ে গেল। He seeks for appropriate orders for ওখানে যে প্রেয়ারটা দিয়েছিলাম রিটেন ওখান থেকে নিয়ে এখানে দিয়ে দেবে। ফার্স্ট প্যারাগ্রাফে বললাম বাই সাচ রিটে এটা চাইছে এটা। অন দি কন্ট্রারি, ওই যে প্রথমে দেখো, হ্যাঁ হ্যাঁ ওইখান থেকে ওটা নিয়ে যতটুকু আছে প্রেয়ার পোর্শনটা ওইটা নিয়ে ওখানে দিয়ে দেবে। হ্যাঁ, অন দি কন্ট্রারি, learned advocate for the respond number 8 submits at the outset that this petitioner
Well, for the statement.
sorry.
submit that
সকালবেলা ভাত থাকে 1 ঘন্টা,
হ্যাঁ
সেখানে আধ ঘন্টা, তুই 1.5 ঘন্টা লেট। কি ইনস্ট্রাকশন আছে? কোন ইনস্ট্রাকশনই নেই।
submit that the petitioner has got no locus standi to file the writ petition since he is a blacklisted company, since he has been blacklisted person, since he has been blacklisted. He also submits that though previously respondent number 9 raised the issue
কন্ট্রাক্টরি পরে
of fake and fabricated documents being submitted by his client,
সুযুক্ত করে the firm
but
have
upon
not to
instruction
the proprietor name.
it is found that
প্রপার্টিটা সুযুক্ত করে।
subsequently respondent number 9 has withdrawn such
তো এই এই মানবমটা
application
থেকে তো এটা
না
for complaint, withdrawn such complaint. He seeks
করে
to
হচ্ছে পরে রিড করলো।
file affidavit in opposition to bring on record the relevant documents. Mr. Somik Ganguly, learned advocate appearing for respond number 9, submits that no such withdrawal of the earlier complaint has been made by his client. State.
What our submission is this, my lord, that is the technical bit when it was rejected. Even if the petitioner want to get the success in this matter, my lord, he will not be benefited because the private respondent who has obtained that particular work order or successful bidder, petitioner nowhere will be the competitor along with the
আমাদের পয়েন্ট
no, that is our contention, my lord. So even if my lord, if he gets success in this writ application, is being a failure as a technical bidder, no right will accrue, my lord. So my lord, he has no locus standi. He might be filing writ public interest litigation under this, that this kind of process has been taken place. This is not done as per the law. But how he will be benefited, that has not been described in the writ petition. That was our contention, my lord.
Mr. Shoipat Chatterjee, learned advocate for the state, submits that the petitioner will not be benefited in either way if the writ petition is allowed in his favor, since petitioner has not at all participated in the tender process.
You have participated.
You have participated.
Yes, but our since we have been blacklisted, I have not been participated.
Since the petitioner was blacklisted, he will not be benefited since he is a blacklisted
এটা ইনস্ট্রাকশন নাকি
blacklisted candidate বা person বা authority যাই হোক, company. It is a company or person?
পার্সন
It's a person, blacklisted person. ये ना ये कम मुश्किल है, इस मुहूर्त में बोलছি opposition দেবে ওইগুলো মুশকিল আছে। लेकिन শুনবো you'll file opposition.
Lordship, would you lordship Kalimala? Though I cannot direct your lordship, my lord.
The difficulty is
Another objection is
enough time was given to the learned advocates to place their cases. Well, after
No.
1 hour,
no.
if you say that you
But subject to correction, what my landed significant says,
My lord.
subject to correction, what my landed significant or subject to his approval, let the matter be delegated to the superintendent engineer. Let him call all the parties. Let it be verified by the superintendent engineer, and he shall take a decision in the matter. That will suffice the entire issue.
Process,
That will suffice the entire issue.
First, he is blacklisted. He cannot, my lord, maintain the writ petition. Secondly, my lord, what he is praying, he has not challenged. He has accepted the page 68 decision of the tender committee. He is relying upon that. He knows that this decision is there. He has not challenged the decision of the tender committee.
I challenge and rather I prayed before your lordship
Now go
to
through the
take
release,
further
not
steps
challenge.
in terms of the decision taken by the tender committee. Yes, that is my prayer.
There is
That
no
is
such
my
prayer.
prayer.
then I dispose of the writ petition.
Yes.
Yes, my lord.
Mother can.
I will make humble submission, my lord. Give me an opportunity to use the affidavit because of factual.
This will longer the petition, my lord, they will get further opportunity to get the another
So,
tender process.
And by
Did such a affidavit in opposition filed within a week or then
Lordship.
reply if any by 3 days.
My lord.
3 days শোনা হয়ে গেছে বেশি সময় লাগে
Shall fix any dates under the heading for orders.
by this submission, we are it is submission, my lord, that we want to preserve our right to file our opposition if so required in future.
Baba.
Because we have no. You have to say what steps you have taken.
Say you will be filing any opposition in this period you can
I
file.
cannot say we can, but I have to raise the point.
Liberty is granted to the state to file any affidavit in opposition to the writ petition. ওই লাইনটা করে দিন
Because we have taken
by the returnable date.
decided for subject to can sanction.
Granted to the state to file affidavit in opposition to the writ petition by the returnable date. 10 দিন পরে returnable motion-এ রাখবেন motion না
Motion.
10 days.
7 days, 3 days, 10 days.
18th তুমি 19th এ রাখো 19th এ returnable motion 19th এ দেখে নাও কি অবস্থা শোনা হয়ে গেছে
Not in the daily supplementary list.
ঠিক আছে কবে হচ্ছে 19th বরুণ বাবু 19th
19.
Madam, it is in top, my lord. If it is in top,
কত নম্বরে আছে 19th এ বলে দাও
much of that. Great.
দাঁড়াও
I'm led by Mr. Somrat and Lanet, additional language.
But 29 and 30. Well, the same, only the private respondents are different.
No, but 30 is actually different. 30, my lord, he is taking the plea that the private respondent whose document we have, my lord, used, he has annexed that letter. That is not, my lord, in this 30. 30 has not annexed any such document.
29 is same
Same.
Only the respondent and the, my lord, package is different. But the same NIT.
No, NIT same.
ঠিক আছে
29 may be same order.
30 before the 30 number of all.
He has paid the same relief. Only difference, your lordship can pass.
No,
the same
29 first
29.
three matters will go who is for the state in that
29.
29
29 before the
29 states.
Hey, state of the
29 if it is.
29
Only the package is different.
all work issued to private respondent all work orders
চিঠিটা একবার দে তো
here the NIT is different
Same.
একবার চিঠিটা দে
same NIT
Same NIT.
চিঠিটা কই?
Same order.
তাহলে same order এখানে শুধু রিটে cancellation of orders issued to private respond number 8 হ্যাঁ blacklisting তো পরে আছে
Prayer B is for blacklisting. Prayer A for cancellation.
and for blacklisting of private respond first হচ্ছে cancellation of all work orders issued to private respond number 8 under ENIT number 3/WBSRDA PUR of 2024-25 and ENIT number 13/PMGSY/Purulia 2024 and blacklisting of private respondent number 8. Mr. Ganguly is also party here.
Yes. 9.
Submissions are same, Mr. Ghosh?
Yes, some
Same koro to submission.
And only by
Which
in both the matter, hearing maintenance of the requisition.
ওটাতেও বলে দিও যে maintain the writ petition point of view kept open shall be decided at time of final discussion. ওটাতে এটাতে সেম হলো তাহলে 30 19 in 29 also submissions are same, Mr. Ganguly?
Yes.
Same. State you will be filing in opposition if required. Same থাকবে 19 30 there is a difference.
30 minute arm for the
12441 respondent number.
দেখো তোমার যে পুরো পেপার আছে কিনা 3 4 5টা আছে কিনা পেজ হ্যাঁ এটা কার হয়ে আমরা
9 and 10.
9 and 10
এটা কি করব? What is the prayer in 30?
30 minute এটা
Same.
এটা
30 minute I'm appearing for the
So the NIET টা আলাদা. You are for the state. Same. Prayers are almost same.
prayers are almost same.
হ্যাঁ এখানে নেবে এ তে বলা আছে এই NIT টা পাল্টে যাচ্ছে.
only that dispute of respondent number 9 is not.
Yeah, the dispute regarding 9 and 10.
9 and 10.
9 and 10.
Well, service হয়েছে কিনা দেখুন.
Mr. Ganguly is applying for 9 and I am for 9 and
8.
8. My land is senior friend, Mr.
You are 8.
হ্যাঁ
দিয়ে দিয়েছে বলছে
Here the NIT is same, no, different.
NIT is different.
Different.
NIT is different.
On 19th.
দিদা তোমাদের নাম
Who is for the state?
না
State দিয়েছে?
I stated 30. I'm appearing for 30 minutes. This is my instruction, my lord.
Learned advocate for the files the written instruction which is taken on record. So the
but later copy the instruction be circulated between us so that we can also deal with the instruction also.
learned advocate for the state is directed to circulate the written instruction to the appearing parties.
Much okay. Grateful.
But I have got.
Yeah, আমাকে দাও another. Thank you. Much okay.
19th এর
Instruction.
রেকর্ডে 30 তে রেকর্ডে থাকে.
My lord, two mention for non-prosecution matter. All 6 matter, my lord, I am for the petition.
All same.
All 6 matter.
Learned advocate for the
I am filing the written instruction in 6 matter. 1 matter order pass, all covered by 6, my lord.
this matter is appearing under the heading to be mentioned. Learned advocate for the petitioner submits that the petitioner does not intend to proceed further with the writ petition. He files written instruction dated written instruction dated
30th/7, my lord.
30th July
Yeah.
2025 of the petition which is taken on record. In view of the submissions, the writ petition being number WPS 3206 of 2025 is withdrawn. Interim order, connected applications of
না এটা রেকর্ডে থাকবে আমরা কি কেন ভয়েস দেয়
আমরা তো এটা অ্যাপিয়ার করছি
ও চুপ করুন না
give your appearance in 2-1 to
6, my lord.
1 to 6. Same order.
Same matter.
No, I am for the item 5 for the statement.
I am deeply honest. গৌতম কুমার ঠাকুর পিটিশনার লিখে তো লিখে দিতে হবে ডেভেলপ
বেশিক্ষণ চলবে না তারা I'm for the petition. My lord, yesterday, my client went over there, post office. There's typical server error in the postal department. My lord, may kindly note that several newspapers has also came out with these matters. But what has happened, my lord, a snapshot has been taken where, my lord, the earlier notice that was served upon the Pradhan contemner that was served. And that has been received by the Panchayat, but seal is there, my lord.
হবে না
The
I give
server
you
is
1
totally
week time, either of the earlier one or the
This is
subsequent
earlier.
one. File an application before the postal authority, get a certificate.
My lord, they are telling that they can't able to provide anything at this moment because the server is totally down. There is the new application is going to be launched by the postal department.
Oh,
My lord, may verify from anybody, my lord. I don't have
no,
any.
everybody is telling so. Get a certificate from the postal department that this has
I
been.
personally went to the GPO and my the petitioners went to the postal department in their locality, my lord. Everybody is
Then
getting the
where
same.
is the acknowledgement?
Well, actually, I have no. It was first through speed post, and I had already submitted the affidavit service, my lord.
No, there is no acknowledgement.
No, my lord. It is without the service has been made. Is the earlier.
If they cannot provide the track consignment report, they have a record in their respective post
My lord,
office.
actually, nothing is there.
No, they have to keep. No?
We
They have to
other
keep.
than this acceptance.
I tell you, you file an application before the postal authority.
They have a direction to serve upon the police station, so the concerned police station may serve it because the
Ashok, the advocate for the petitioner submits that due to technical glitch in the server of the postal authority, the track consignment report in respect of the consignment sent to the alleged contemner could not be obtained. Petitioner, learned advocate for the petitioner is directed to approach the postal authority for obtaining a certificate showing service upon the alleged containers. When can you do that?
kindly keep it after
And file
7
an
days.
affidavit of service on the returnable date.
After 7 days.
Is this matter after 7 दिन पर आज के दिन है after a week under this same heading.
It's very much unlucky from 2023 is
What
rotating,
to
and
do?
now due to the technical glitch in the postal department, my lord.
এটা রিটার্ন করে দিন কত তারিখ আছে 21
Developed.
সেকেন্ড হাফ তো শুরু হয়ে গেছে ডাকুন Who is for this?
I called Mr. Alok Banerjee and Mr. Arjun Roy Mukherjee is appearing, my lord, engaged in this stage. My lord, Alok Mukherjee told me that yes, I will be there.
Matter, just now I have been instructed to appear, my lord, on behalf of the state respondent, my lord. The only instruction that I was just going through is that already a letter has been written to the finance minister for the balance amount of 2 lakhs. Some direction with a short time period, my lord, that will do. Perhaps the substantial amount has been paid. If your lordship kindly have a look at page.
The amount is admitted.
My lord, yes, that's what I have seen. My lord, page 17 speaks about that, and a substantial amount has already been paid. My lord, only 2 lakhs is due out of 6,99,000.
Affidavit service filed on
But
behalf
as
of the petitioner is
the
taken
amount
on
has
record
been
by the
disbursed from the finance, my lord,
present-
that could not.
present writ
Yes.
petition. The petitioner seeks for appropriate direction upon who is the authority? Who is
My
the
lord,
authority?
affidavit I have given my.
Who is the authority? Who will
Oh,
disburse
my lord, yes, ma'am.
direction upon the respondent authorities to
My lord,
pay
the respondent number, block development of
the outstanding amount of rupees 2 lakhs
BDO is
pertaining to
the
supply
my
order
lord, respondent number 5, my lord.
pertaining to supply order dated 12th December 2018 within bracket annexure P1. Learned advocate Mr. Swansol, learned advocate for the petitioner, submits that the petitioner has participated in the bid and he has executed the work in terms of the work order issued in his favor. There is outstanding dues of 2 lakhs which has not been disbursed as yet despite several representation. Learned advocate for the state concedes the amount of rupees 2 lakh to be outstanding is 6.
But instead of
Some-
concedes, my lord, the instructions are like this, my lord. May I
On
hand it over the instruction, my lord?
Concedes. Learned advocate for the state submits that as per the instruction, the fund of rupees 2 lakhs is outstanding. He seeks amount of rupees lakhs is outstanding.
But as the fund is not available from the finance,
The
my lord, this could
fund
not be
is not
disbursed.
available. Such amount could not be disbursed. Upon hearing the learned advocates for respective parties, it is found that the amount outstanding of rupees 2 lakhs is admitted one. Accordingly, respond number 5, block development officer, is directed to take steps for disbursement and program. Block development officer and program officer under Manrega. Disbursement of the amount of rupees 2 lakhs in favor of the petitioner within a period of 4 weeks from date of communication of this order. Disposal. উনি সাবমিশন ফাইল করেছেন, এটা নিয়ে নেবে ইনস্ট্রাকশন।
Deeply obliged, my lord.
নেক্সট
I'm grateful.
For the private respondent requisitionists.
My lord, in 31, I'm praying for not today, my lord. Mr. Rohibul Islam is appearing.
No.
He's
every day cannot go on like
No, my lord, in February, the requisitions, they lost their majority. Even then, they are in position by obtaining X, Y, whatever may be the order.
but can it be passed over, my lord, since he is in my lord hospital, my lord? He is in his way, my lord. Can it be, my lord, pass over, my lord?
You have to understand, once this goes tomorrow, God knows when this will be taken up again. For
Because
3 days this is going on. You were enjoying the interim order.
My lord, interim
You
order
want
has been.
interim order.
It was, my lord.
Even after getting
ended,
the
my lord.
interim order, you are not participating in the hearing.
Well, since my senior is engaged, my lord, I cannot
Stall,
do the
meeting
I
cannot
cannot
be
move
held.
the matter, my lord. That is
But
difficult.
since they are taking the plea of medical urgency, my lord, kindly fix the matter tomorrow at top, my lord, because we have been suffering. We, despite of having our majority, my lord, since February, we are not able to remove them from their post.
13th June, then 26th June, 4th July. কালকে রাখো, not today. ডাক দিয়ে রাখো, not today.
Finally fixed at 2 PM, my lord.
2 PM এ কালকে কি আছে দেখো তো। দুটো আছে, থার্ড এটা রাখ,
Great, my lord.
কালকে দুটো আছে।
Great.
My lord, I beg to appear on behalf of the petitioner. My lord. My lord, this is absolutely, my lord, the pure question of law. Whether the video can, my lord, call for any e-tender as per the statute conferred upon the, my lord, Panchayat Act. This is the, my lord, the only. My lord, this Panchayat does not have any, my lord.
What is the
What?
nature of the work?
My lord, kindly have a look, page 18. 18 to
40.
18, 1-8. My lord, the next page, this is the notice, and next page is, my lord, the work order.
No, where is the notice inviting e-tender?
My lord, page 18.
Meeting regarding issuance of NIT.
এই নোটিশটা কোথায় গো?
এই তো নোটিশ।
ও
কোনটা? 18.
this one, 19.
19 is the, my lord, the
This is the notice
tender.
inviting e-tender.
Yes.
Same order of 17/5.
Yes. Yes, your lordship has passed on. I have that order. এই দাঁড়াও না, তুমি কেন বিরক্ত করতে যাও? স্যার তো জানেন এটা already decided
Bathroom
this
moved
issue.
in application. But who is for the state?
My lord, I have served everybody. Twice the matter was taken up by your lordship. দিয়ে দিয়েছো তো? হ্যাঁ, সবাই, everybody has got it.
Only the state is the party.
State.
কাউকে appear করতে হবে state.
কাকে কাকে দিয়েছে দেখো তো?
Deepak,
State, page 5,
here is a private respondent is there.
EM, ADM,
Private respondent has been served.
My lord, this is Bhaskar, Nirman Shah. He has been served. All are state.
page 10,
Page 10 of my lordship's, my lord, the affidavit of service. Nirman Shah.
Anybody from the state panel is present in court? দেখো তো বাইরে কেউ আছে? কেউ আছে? ললিত মাহাতো বাবু?
কেউ আছে স্টেটে দেখো না।
Mr. Mahata is there.
He is there. He is the state.
Where is Mr. Mahata? Affidavit of service filed on behalf of the petition is taken on record. So you are for the state?
8 minutes. Led by Mr. Mohit Mukherjee.
No.
Oh. Why?
I'll tell you about it. So far as Mr. Mohit Mukherjee is concerned, there is a postpone violence matter of 21, but I am appearing from the accused. Matter has been fixed at 3. My Lord Justice Sengupta is going to hear me, but still I'm here. Mukherjee is for the de facto contract.
25 এ আরেকটা ম্যাটার আছে।
That is why, my Lord, she's correct.
Connecting matter, my Lord.
So I want to do my matter after this, and I will leave.
তাহলে কি হবে?
Kindly keeps it as an off today, my Lord.
আরে ওর বলার কিছু নেই তোমার বেশি। This is covered by your lordship, so many diseases.
We'll see tomorrow. Let him come. If he has got any submission to make, I can nail it on them.
Well, then in that event, let it be short fast over so that if he comes to compliance, because পারবে না।
একটা ম্যাটার ফিক্সড আছে আর 3 তে একটা ম্যাটার ফিক্সড আছে, পুরো টাইম ফিক্স ম্যাটার।
কমপ্লিটলি আছে। ইফ এনি গভর্নমেন্ট আছে তাহলে ডেকে আনবো কি?
কালকে আস।
আরে মাহাতো এলে তো ও তো টাইম চাই।
Not today. Yes.
Make these elections.
Now your other side is there.
How eager I am for so far as this matter. I had appeared virtually also, your lordship knows. But this is a case which has been pending. So, my lord, she was correct because I am going to argue at 3 p.m. before my lord Justice Joyshan. So, anyway, my lord, I will start my matter. May I file my affidavit of service? Kindly. This is the problem, my lord. This is the third time your lordship knows, my lord. My lord, this is a case where, my lord, the petitioners have duly contested the Panchayat election 2023. My lord, they all received the winning certificates on July 11, 2023. Now, my lord, this is in regard to Daldoli Gram Panchayat. My lord, 10 candidates, all total 14 candidates were elected. Now, my lord, 10 from TMC, 2 independent candidates, 1 from BJP, and the other one was from Kundvi Samaj Party. Now, my lord, on 10th of April 2023, board was constituted of 6. That is what the prevailing law is. 4 from TMC candidates, excluding these petitioners, 2 independent candidates, 1 independent BJP, and 1 from Samaj Kurmi Samaj. Now, my lord, respondent number 9 was Pradhan, and respondent number 10 was Upa Pradhan. But on March 7, 2025, 2 candidates, 1 from TMC, that is Upa Pradhan, respondent number 9, and the independent candidate had resigned from the committee. Now, my lord, what happens next? My lord, we write
9 have resigned.
2 from 6. No, 14 were elected candidates. 6 committee formed. Pradhan, Upa Pradhan, and along with 4. 4 were TMC candidates, but these petitioners all were TMC candidates, but they were not given a chance. Now, my lord, the petitioners who are there before your lordship are aggrieved in the sense, my lord, they've withdrawn, these 2 independent candidates withdrawn their support, that your lordship will find at page 32 and 33.
Their petition numbers?
These are, my lord, the Upa Pradhan being respondent number 9, and the other one is respondent number 11. Kindly comes to page 32, your lordship will find that. It is in Bengali, my lord. May I read?
No, I can.
Yes.
Okay. So he has resigned.
Yes. So automatically, in 6 committee members, if 2 resign, and several representations, the law is, which I will refer to, but the BDO has to immediately call upon and to verify whether that has been done voluntarily or not, whether he had given this resignation, and after that, if it is proved that he has given the resignation, automatically the committee dissolves. Now, on the verge of this, even after 7, now this 4 committee, they are issuing tenders, which is completely illegal and unconstitutional. My lord, that your lordship will find at on 4th of June, rather, my lord, 2025, petitioner was shocked to notice that e-tender notice has been published at the office of page 41. Kindly comes to page 41. Despite representations, despite, my lord, going to them that kindly make a hearing, call the parties, and this entire committee should go. Now they have, on 4th of June, my lord, this notice has been invited from the Pradhan. This is what is going on.
Where is the representation?
My lord, that your lordship will find. Kindly comes at page 50. All these petitioners made a representation. Thereafter, 52.
SDO is the prescribed authority.
SDO, thereafter the Pradhan, and thereafter your lordship will find, my lord, the BDO also, page 48. I'm sorry, my lord, I should have shown page 48. BDO, Block Development Officer, is the prescribed authority.
And also page 46, sorry, my lord, that is to the district magistrate. Continuous representations. It starts from 46 actually.
What is the provision?
Yes,
Which
sir.
provision?
My lord, I will show you, lordship. এটা মুড়ে রাখলাম কোথায় গেল? Yes. My lord, will kindly have a look at section 10, resignation. Resignation of Pradhan and Upapradhan, what the prescribed authority is supposed to do, my lord. It has been prescribed.
And the consequence of this resignation that the committee should have a body of 6.
Now there is no 6.
No, where is that? It should constitute a body of 6.
Lord,
Whether the existing can take a decision, the existing 4 can take a decision.
my lord, that is, my lord, there has to be a, your lordship sees, my lord, it is 14 candidates who have been elected. So, my lord, your lordship takes 1/3. It comes to 6. Now, in this present situation, there is not 6, only 4. And Pradhan cannot work in this fashion, my lord. My lord, I should have been given an opportunity of hearing also by the concerned authority, block development officer. They should have called me.
State, you are for the state? Mr. Mahatma is there? Ask him to come.
My lord, may I pray for one thing? Can I talk to Mr. Mahatma so that he comes and I can come back at 3:30 so that it's a short passover. 3:30, I will contact him just going out of the court and I will request him to come here.
Then 3:15, make it 3:15.
Lord, I will argue, my lord, because it's my
3:30, I will take a returnable motion. Anyway, you come.
Can it be just 4 o'clock before your lordship rises?
4 o'clock is assigned matters. 3:30 before returnable motion.
I'm so grateful. At least I will take around 20 minutes time to argue there, my lord. Because for last 7 days we have been arguing. Now I think today my lord will pass an order. I'm so grateful.
Keep your affidavit in service with you.
বইটা থাকুক সাহেবের কাছে আমি আসছি। I'm so grateful.
I have a book, so you can take. বইটা দিয়ে দিন। Oh yeah.
But in this matter, I am for the petition.
Miss Shongita Rai is appearing in this matter for the state. She is on her legs in court number 4. Lordship, I am praying for only not.
But I have a very innocuous prayer. Very innocuous prayer. I hope my learned will not suffer by this order. What I am praying. But what is my case? But I am a helper of a Shishu Shikha Kendra since 2005. Well, since 2005, I am working in that particular Shishu Shikha Kendra. My appointment letter is, my lord, is just, my lord, page number, your lordship may find, page number 12 and onwards. I have been appointed particular Shishu Shikha Kendra, Mustafapada Shishu Shikha Kendra. I am a helper. But since 2005, I am working in that particular Shishu Shikha Kendra successfully. There is no allegation against me. Suddenly, my lord, in the month of, my lord, in the month of month of January, possibly, my lord, in the year 2025, a transfer order has been issued by the concerned authority, state authority. I have been transferred from this Mustafapara Shishu Shiksha Kendra to Gopinathpur Shishu Shiksha Kendra, which is far away from my residence. My lord, I am suffering by serious ailments in my 55 years age, arthritis, all medical papers I have annexed. Even my lord, that transfer Shishu Shiksha Kendra, where from Mustafapara Shishu Shiksha Kendra having 117 students, which I have pleaded in my writ application, but there is 4 helper including me. If Right to Education Act applied, my lord, 30:1, which is, my lord, pupil teacher ratio is not favorable, which is adverse. My lord, Right to Education Act, 30 students into, my lord, 1 pupil is required, subject to, my lord, correction. My lord, here, my lord, 117 student, my lord, 117 student and 4 teachers is there, which is also adverse. My lord, after 90 student, my lord, 4 teachers helper concept may come. So which is adverse, my lord, which I have been, my lord, transferred. My lord, I made a comprehensive representation before the district magistrate, my lord, who is the ultimate authority to decide the issue. From where I am getting, my lord, there is a clause in my appointment letter. Your lordship may find, that clause. My lord, page 13. Page 13. Yes, my lord. My lord, page 14 of that clause. My lord, kindly see. My lord, page 14, clause 13. শিক্ষা সহায়িকা সহায়ক বিষয়ে দায়িত্বভার গ্রহণ করার পর শিশু শিক্ষা কেন্দ্রের পরিচালক সমিতির কোনো সিদ্ধান্ত বা আদেশ শিক্ষা সহায়িকা সহায়ক সম্পূর্ণ বা আংশিক নীতিবিরুদ্ধ বা চুক্তিবিরুদ্ধ পরিবিধানের পরিপন্থী বলে মনে করেন, তাহলে শিক্ষা সহায়িকা সহায়ক উক্ত সিদ্ধান্ত আদেশ জারি হওয়ার 1 মাসের মধ্যে সংশ্লিষ্ট জেলা শাসকের কাছে আপত্তিকর সিদ্ধান্ত বা আদেশের সম্পূর্ণ বা আংশিক বিরোধিতা করে লিখিত পত্রাকারে জানাতে পারেন। আবেদনপত্র পাওয়ার 1 মাসের মধ্যে জেলা শাসক নিজে বা তার দায়িত্বপ্রাপ্ত অন্যান্য মহকুমা শাসকের স্তরে কোনো আধিকারিক বিবাদমান 2 পক্ষের বক্তব্য শুনে সুনির্দিষ্ট আদেশ জারি করবেন। That clause is there. Accordingly, my lord, against this
transfer order has been issued by which authority?
Yes. Transfer order, I am coming, my lord. Transfer order issued by the your lordship may find page number 58 and onwards. Just a minute. Transfer order, page number 58 and onwards, seeking explanation for non-compliance of the order by memo number so and so, that is issued by the executive officer Rani Number 1 Panchayat Samiti. Well, at 3rd April 2025, due smooth functioning of SSK, you have been transferred from.
Where is the transfer order?
Yes, that is the transfer order. My lord, even thereafter, I made comprehensive representation before the DM, but at one after another, I am unable to join, my lord, due to my old age.
Where is the transfer order?
Well, this is the ballot seeking a transfer exact. Yes, my lord, transfer order, page 20. Annexure P5. 4th of March 2025. Urgent exigencies following transposition and made smooth functioning of the SSK serial number 3.
You have not joined your news.
I am unable to join. My honorarium has been stopped. Even, my lord, despite I made representation before the DM. I am only praying, my lord, let the DM consider my application after granting an opportunity of all the parties. If the DM find that otherwise, my lord, I have to join, having no other alternative. That prayer only, I am innocuous prayer. Only that much I am praying before your lordship. Kindly consider my tender age,
yes,
and ailments.
You are for? What is there? Is there any objection from the side of the
Considering the representation.
all matters will fix tomorrow, then what will
Yes, well, my lord, DM after granting me opportunity of hearing, pass necessary order. If my representation page 78, comprehensive representation, at least consider my case. Well, there is a clause. My tender age, my lord, on the age of 55, 56, I have been transferred. I am suffering my medical ailment. Only consideration. I am not seeking any mandatory order. Since my representation is pending, it is the duty of the authority to redress my application. And immediately thereafter, I filed this writ application. So only I am paying disposal of that writ application. Nobody's will prejudice. If the DM think fit, then I have nothing to, then another recourse will come. But at least they should come a conclusion, my lord.
how long? What is the distance between the present posting?
Yes, present, my lord, distance I have annexed, my lord. That distance I have, distance proof I have annexed, medical document, distance. My lord, distance is, my lord, then I have pleaded it also. Which is more than 10 kilometer, my lord. And present Shishu Shiksha Kendra is 200 meter. And my lord, entire medical document I have annexed. I am suffering by arthritis and another chronic disease. My husband is also suffering by some ailments. I am the only caregiver.
Affidavit of service.
Yes.
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks for consideration of his representation dated 3rd May 2025, being annexure P7, pending before respondent number 3, District Magistrate, Murshidabad.
Yes.
The petitioner contains that the joint Mustafa Pada Shishu Shiksha Kendra on 25th May 2005 as a Sahayika and discharged her official duty accordingly. By later under memo number 226 within bracket 15 dated 4th March 2025 issued by the Executive Officer Raninagar 1 Panchayat Samiti, Executive Officer again, respond number 5, comma, the petitioner has been transferred from Mustafa Pada Shishu Shiksha Kendra to Gopinathpur Shishu Shiksha Kendra, which lies at a distance of 10 kilometers. The petitioner is aged about 55 years and is suffering from various ailments. Due to the said reason of ailments, the petitioner could not join her duties in the new place of posting. The petitioner made representation before the respond number 3, District Magistrate Murshidabad, for considering her representation for posting in a nearby place. What is your prayer, mate?
My lord, There I remain want to stay in my present post.
Interest. Okay, make representation for redressal of a grievance. Since he intends to stay in the same school, same Shiksha Kendra, Shishu Shiksha Kendra. The said representation of the petitioner has not been disposed of, hence this writ petition. Learned advocate for the petitioner submits that as per clause 13 of the agreement dated 25th May 2005, any decision taken by the management committee can be challenged before the district magistrate.
Yes.
The district magistrate is under obligation to consider such representation of the petitioner. He seeks that specific direction be issued upon the district magistrate, response number 3, district magistrate Murshidabad, to consider the representation of the petitioner. What is the date?
Another submission I have, my lord. My lord, pupil teacher ratio is not also favorable.
That lies with the administration.
Lordship. My
3rd May 2025. Learned advocate for the state. What is your submission? No, not today. This is a simple matter. This will be decided by the district magistrate. Either he will reject or allow her prayer. Yes. Will you make your submissions? I will pass an order. The advocate for the state leaves the matter to the discretion of the court. On hearing the learned advocate, response number 3, district magistrate Murshidabad is directed to consider and dispose of the representation of the petitioner dated 3rd May 2025 upon notice to the petitioner by a reasoned order in accordance with law within a period of 4 weeks from date of communication of this.
Well, an opportunity of hearing.
Upon notice.
I am extremely grateful.
And hearing heard.
Great.
I 35 I am praying for non-prosecution.
You are for state?
My lord, the matter related to my lord, the disqualification of the members, my lord, in respect to the provision of 213A of the Panchayat Act, my lord. The respondent number 5 voluntarily, my lord, left the political party. On that ground, my lord, we have intimated the prescribed authority to decide the issue, my lord. Relates to my lord, the disqualifications of of that member, my lord.
This has not been decided.
No, my lord. And except we, my lord, since my senior is engaged in this matter, my lord, kindly do not pass any order, my lord. Keep it, my lord, not today, my lord.
There's so many matters, not today, tomorrow. How many matters?
Since I do not have any instruction, my lord, Mr. Islam is appearing, my lord. He has the instruction, my lord.
Who will conduct?
My lord.
Who will conduct the case?
My lord, prescribe video, my lord. Prescribe.
Then what is the difficulty? What is your prayer?
It's number 13.
Immediately initiate and complete the discussion.
My prayer is, my lord,
Get
the
yourself ready with that.
disqualification from the.
Get proper instruction from your senior and move this application.
I
There's
called
nothing
him, my
in
lord.
this.
Since he is in hospital, my lord, I could not able to, my lord, take my call, my lord. That is the difficulty.
Small matters, how long it will take? You have
Keep
mentioned
the
the
matter as it is, my lord, in the list, my
Yep.
lord.
Upon your mentioning, the matter has been listed
Yes, my lord.
as a top. Now there is no advocate to proceed.
My lord, he could not able to come, my lord.
Then make it out of list then. What to do?
No, my lord, kindly keep it not today, only for my lord.
Not today. What is happening is not today means the items are going on the next day. So what will happen to the items which are down the line? If everybody comes and says not today, what will happen then? I have allotted 3 days for 2025 matters. Now the first day, Wednesday, everybody is coming and saying that no, not today. If you are not ready, then why are you mentioning the matter for the top? There are other matters will be taken up at top. Get yourself ready. What is the matter? You ring him, get instruction and move the application. Let it be disposed of.
My lord, I called him, my lord, since he is not attend my call, my lord.
Now tomorrow you will come, the state will not be there, you will be next in another court. Next.
Thirty-six.
36.
My lord, in 36, I am representing state respondent, my lord.
Yes.
You also state regarding.
Who is for the petitioner?
Panchayat.
Okay.
My lord, it's a tender related issue, my lord. And we do not know what has happened, whether the work order has been executed or not, my lord. We have not received our instruction, my lord.
The issue
My lord, since petitioner is also not there, my lord.
Wait, yes, Mr. Amit.
what has happened with the petitioner says that the labor license was sought from in the tender as a document. They said that that was an additional document which ought not to have been called for by the Panchayat. But this is a statutory requirement not under the government of West Bengal. Since unless there is 1% deduction of cess on the final bill, that has to be deposited because of the deducted from the final bill for the benevolent fund. So that is the reason that the Panchayat has asked for the license.
Labor license.
Labor license. That is the only grievance. And in that garb, they say that private respondent has been facilitated. But that's a statutory requirement. That is the reason it was called. Petitioner is not here. Your Lordship would kindly dismiss the
Okay. None appears on behalf of the petitioner. Your private response number?
Number 6.
Private response number 6 is no private. No, this is Pradhan. Pradhan of Chori Anantapur Gram Panchayat. Response number 6 is represented for the state as well as Kuradin. For instance, justice, the matter is adjourned. List this matter. Next, pick it up. Next Wednesday.
Wednesday.
Next.
Obliged, man.
3:30
No, no problem. Mentioning is a topic.
Can it be fixed on Thursday?
First,
Thursday.
13th.
Can I? Marital law. Huh?
37. None appears for mentioning. None appears on behalf of the petitioner. State is also not represented. Done. For interjustice matter is adjourned. This is matter on 13th. যেখানে নিচে যাবে যাবে. Your other side has come.
But I had my perhaps Mr. Mahato, my lord, he said that he is engaged in a matter at 3:30. So that is why it was very difficult for him to come again because he has gone to the other building. That is what he told me. So my lord, the difficulty is in this case, my lord, your lordship was inquiring regarding the provision. My lord, perhaps the provision is not required. 6, now 4, and the representations were not considered. This is what my case is. And apart from that, they are now issuing tenders, which is completely illegal.
The state has to be heard in this.
এখানে স্টেটের কেউ আছে?
Mr. Mahato has been appointed in this case.
No. That is what
I called him.
because no one was there, your lordship.
Take instruction from the operator.
Tomorrow.
That will be helpful.
Tomorrow.
At what time, my lord?
কালকে কি আছে দেখো তো. এটা তো
একটা টাইম ফিক্স করিয়ে নাও। না একটা টাইম ফিক্স করবো। আমি 4 বার এটা নিয়ে আমি তোমাকে লজ্জা মানে আই এম ভেরি 4 বার এটা সব দিয়ে দিচ্ছি।
কালকে কখন দেবো? হ্যাঁ 3টে 2 PM এ আছে তো এটাকে 2:30 তে রেখে।
আই এম সো গ্রেটফুল। I'm going to 3 PM. I'm so grateful, my lord. Sorry to bother, my lord.
All right. চলো নেক্সট 3:30 আমরা
তুমি সব দেখে নাও। তোমার যা যা লাগবে দেখ।
রিটার্ন
My lord, reasonable motion, my lord, I am for the statement. I went to medical checkup for myself, my lord. I could not bring the zip and customer
instruction.
Your Lordship, Advocate Jui Datta Chakraborty is for the petitioner. She is engaged in some other court. Your Lordship, I'm praying for a short passover.
What is the report of the state? This is a due amount, outstanding amount is due.
Lordship.
What is the report of the state?
not my lord. I mean, not today.
Not to.
Obliged, Your Lordship.
Where is Mr. Sen?
922, we are appearing for the petitioner.
Other side here. State to nahi.
State, Mr. HON'BLE Sen was addressing your lordship on the last occasion. He was supposed to argue today also. He did not complete on the last day. Lordship kindly recollects that matter where my lord the petitioner. Yes. Lordship wanted my lord the traffic marshal. But the traffic marshal which we relied upon, my lordship wanted a copy of this.
Yes.
জুনিয়র কে আমরা কি করে শুরু করব? জুনিয়র কে নিয়ে আসো।
Yes, sir. Where is Mr. Sen?
I can deal with the points which have been taken by Mr. Sen.
Concluded.
No.
No, concrete point.
Kindly make it. I will call him.
He's coming.
I'll call him. Give the call.
ঠিক আছে একটু পাস করতে। ঠিক আছে চল একটু পাস করতে।
Same problem. May it please the Lord. I'm for the petitioner.
Yes.
So far as
Priority to file report.
Lord, this matter was heard earlier by His Lordship the Honorable Justice Ravi Kishan Kapoor.
Report any? No report.
That report has to come, otherwise it's very difficult. I was a candidate, my lord.
Subject post, this may be. Oh. You secured the second rank.
Yes. Now what has happened, my lord, upon instruction, I'm saying, my lord, so far as the petitioner who is the private respondent here, she has expired. This is there, my lord. This is upon instruction. I have not got any document from my client, but the petitioner who was engaged, the private respondent who was engaged, she has expired. So
your name was in the waiting list?
No, I was selected, but there was some difficulty in regard to the age. Initially, the documents which was provided to the authority concerned, they said that the Aadhaar card, they disputed in regard to the age. But my lord, I have to satisfy your lordship. But now, because I am second in ranking, my lord, if she has expired, if a report comes to your lordship, my lord, then I will be entitled. This is what my humble submission is.
None appears on behalf of the state. By order dated 6 November, 25th November 2024, the state was directed to furnish a report. Mr. Imtiaz Ahmed, learned advocate for the petitioner, submits that no such copy of report has been served upon him. Please this matter Wednesday, next Wednesday. Next 13th, 13th, 14th, return of motion. 13th. Urun Babu. 13th, devo returnable motion. Huh? When the advocate for the petition is directed to.
In this matter, I am for the state, my lord.
Oh.
If it has been.
Oh, you are there.
Ready. Report has been.
Give a copy to him.
My lord, a copy has to be served to me, na?
Already served.
When?
A report in this. A report in the form of affidavit filed by the state is taken on record. Copy served.
Yes, my lord.
No. Someone has. আমাকে একটা দিয়ে দিন না. I will take an exception if required. I will take a copy from my lord.
A copy has been served or not?
Yes.
To whom?
9th November 2014.
You have to copy.
কে সই করেছে কি মিঠুন আসছেন
Copy.
But one copy has been handed over, my lord. I will. Let me come back on 13th after going through this.
13th. Mr. Imtiaz Ahmed, petitioner seeks to file a exception to the report. If such exception be filed by the returnable date, release this matter on 14th. 14th and 19th.
19th. I'm so grateful. আমি এটা নেব? I'm so grateful, man. I'm deeply.
Yep. Yes. 922.
Pass over. এখনো কেন আসছেন recruitment policy memo, I think, on the last professor, I have handed over. No further copies with me.
Yes.
There is one copy. Now, may I start? Now, my lord, kindly come, my lord, first that, my lord, page number 30 of the writ petition. Page number 30 of the writ petition. This is the, my lord, starting point, the foundation of their case. Now, this is, my lord, the engagement as work charged employee. Have you also got it, my lord? By the Jela Parishad. Then, Lordship kindly come, and it was in January 1988, purely temporary. And then, Lordship kindly come to, my lord, the next page number 32.
Yes.
Principal Secretary to the Executive Officer. It appears it is a memo that creation, jo caption is creation of post for effecting uniformity in the staffing pattern of Jela Parishad. There are several posts. Must be some uniformity, that matching. Now, Lordship, kindly come to clause number 3 of the memo. The Jela Parishad of this state have been arranged into 3 separate groups depending on the number of Panchayat Samiti within their territorial jurisdiction for the purpose of determining the admissible numerical strength of the staff of different category in the corresponding administrative setup. So it's a guideline, almost. With regard to the, my lord, the appointment to several, my lord, the post guideline. Now, very important, the clause number 4. It is their document, that's a kindly considered thing, but the record of the state. All posts of the Jela Parishad mentioned in this memorandum shall be filled up in the manner laid down in the West Bengal Panchayat recruitment and condition of appointment of employees of Jela Parishad rules 1997 to be published shortly. This memo carries the date of 21st of March 1997 at the top right hand side. 21st of March 1997. And regulation was forthcoming at that point of time. That is why it said all posts of the Jela Parishad mentioned in this memorandum shall be filled up in the manner laid down in the West Bengal Panchayat recruitment and condition of appointment of employees of Jela Parishad rules 1997, then rider to be published shortly. So now the admitted position is that after this 21st March 1997, that recruitment rules was published. Till today, that recruitment rules are to be followed. There is no further amendment. It is nobody's case. Now, Lordship, kindly come to page number 38. It is all their document, page number 38. I am relying upon all their documents, page number 38. Have you also got it, my lord?
Yes.
Page number 38. So, initial induction to the Jela Parishad on January 1988, as per page number 30, as a purely temporary work charge. Now, total status change, page number 38. And he accepted that. Joining report in the post of assistant cashier, Jela Parishad, Bardhaman, at the top. And it was dated 1st April 2003. As per your order mentioned above, I am submitting my joining report in the post of assistant cashier on 1st April 2003 forenoon. It is for your information that my qualification is diploma in civil engineering. I am working as WC sub-assistant engineer 88, that is work charge, as a temporary since 15 January 80 till date. Now he says this, though I am possessing diploma in civil engineering, rather I shall comply with the post of assistant cashier. And it was his request, if in future there may be any vacancy for the post of sub-assistant engineer, I may be offered the post. So otherwise, now this letter was followed by the actual order. Let's see, kindly come to page 39. The next. Sri Buddheshwar Roy, the petitioner, is hereby appointed provisionally subject to confirmation after satisfactory and qualified service of 1 year or more from the date of joining to the post of assistant cashier in the pay scale such and such, read with section 6 of the West Bengal Panchayat recruitment and condition of appointment of employee Jila Parishad rules 97 under approval of such and such Jila Parishad, meeting date at such and such. He will have to submit a declaration. He will remain on probation. So this order giving him an appointment to the post of cashier, rather assistant cashier, there was no such clause or no rider, no undertaking, no promise that at any future point, if situation so arises, then you will be offered to the post of sub-assistant engineer. No, nothing.
Yes.
So, my lord, the factual aspects up to this was that from temporary work charge engineer or sub-assistant engineer, temporary, then, my lord, shifted to permanently cashier in 2003, all accepted without demur, without any further assurance, anything. Then in 2007, Jila Parishad gave an appointment to sub-assistant engineer. Now, she kindly come to page number 42. Yes, page number 42. Page number 42. Recruitment rule study. Yes, page number 42. Naturally, the petitioner is now heavily relied upon this because the next chapter is opened from this stage. Sri Buddheshwar Roy, the petitioner, is hereby appointed to the post of sub-assistant engineer, Bardhaman Jila Parishad on promotion. This is very vital. Not a direct recruitment. On promotion, in the pay scale, he will remain on probation. But probation is naturally, on promotion by executive officer, Bardhaman Jila Parishad. Now, if I draw your lordship's kind attention at this stage, because entire thing depends at this point. This is the entry point. if I satisfy your lordship that this entry point was illegal, not irregular, my learned friend naturally said, according to him, that there might have some irregularity but not illegality. But our contention, our stand and facts remain that this is illegal, not irregular, because of the fact that this is dehodes the recruitment rules. Now, lordship, kindly come, because they said it promotion. Appointment on promotion. So from assistant cashier by way of promotion, the next post, that is sub-assistant engineer. That means if I say in otherwise, revert the clock in this way, then that means that the post of assistant cashier is the feeder post of sub-assistant engineer. Now, lordship, kindly come to that, my lord, the Calcutta Gazette, their rules that I have handed over to your lordship on the last occasion. It is dated 21st of May 1997. My lord, kindly have it. আমার কপিটা নেই, জজ সাহেবকে দিয়ে দিয়েছি। সেই প্রমোশনটা আমাকে সেটা কি একটা কপি ওখানে কি করে আমাদের সেইটা আমাকে দেখো। তো ইয়েগুলো দেখাবে যে আমি কোন কোন সাব-অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ার 16 না কত? Yes, 16. My lord, I think it is page number 7 of the notification, and my lord, the page Roman 16.
Yes.
At the bottom, the caption sub-assistant engineer civil, electrical, scale of pay, then method of recruitment. Have you also got it, my lord?
Yes.
Then method of recruitment. My lord, kindly come to this, my lord. This is very vital and method of recruitment by absorption of draftsman, tracer, surveyor, estimator, having the qualification laid down in subclause E and working against a sanction post under the Jela Parishad on being appointed in a regular manner before the commencement of these rules. These rules, my lord, naturally came in 1997, May 1997. 37. And the 37. The provision is that the method of recruitment by absorption of draftsman, tracer, surveyor, estimator, having the qualification laid down in subclause E and working against a sanction post under the Jela Parishad on being appointed in a regular manner before the commencement of these rules. So there are so many clauses, my lord. Conjointly, it is stated therein that first of all, absorption from draftsman, tracer, surveyor, estimator, not cashier or assistant cashier, no question. Having qualification laid down in subclause E and working against a sanction post under the Jela Parishad on being appointed in a regular manner. Even when the question is that whether even that appointment to the post of sub-assistant cashier, whether it was a regular manner or not, because our contention, it was not a regular manner. Thus we can choose.
Lord, one interruption, my lord, all other matter release, my lord. Yes.
So, 4 p.m. fixed.
4 p.m. is now 53. It is not 4.
All of the matters.
No, no, assign matters not. Only group 5 matters. Only group 5 matters. The scale of pay, which is appearing at page 42, is not matching with 16.
Scale of pay is also not matching. Because in 2007, so kindly consider one thing. Because scale of pay, according to them, they have, my lord, fixed the scale. The Jila Parishad fixed the scale.
How can that be?
Not according to.
State our mind.
Then you have a copy of this GO 988, which has been referred to in the order.
Yes, 988 of 21st 3 1997. 988 I think annexed here. GO
But then
of
if
1990.
there is a reference of the recruitment rules, can the Jila Parishad fix a scale for the?
Possibly not. No question. 988 is at page 2. I'm sorry, page 32. P2. Which I brought to your lordship notice.
For this one?
Yes.
Okay.
Where it was specifically mentioned at the bottom that all posts of Jila Parishad mentioned in this memorandum shall be filled up in the manner laid down in the West Bengal Panchayat Recruitment and Condition of Appointment Rule 1997 to be published shortly, that is forthcoming. And despite being the fact that it was mentioned in that order of at page 39, that GO number 986, but contrary to GO number, or my lord, that is my lord, without following that GO. They said there, yes, as per provision of GO number 986. GO number 986, there is no such power, my lord, given to the Jila Parishad to fix the pay scale or to give such appointment deholds the rules. But mentioned here, the as per provision, that is also not correct. It was not correct.
Yes.
Now, when these requests were, my lord, one after another, my lord, forwarded to the authority concerned, that is the, my lord, the state government, the deputy secretary to the government of West Bengal, for post facto approval. In 2013, let's kindly consider at page 56. At page 56, way back in 2013, because he was officiating that. And in 2013, OSD ex officio Deputy Secretary, Government of West Bengal, wrote to the Additional Executive Officer, Bardhaman Jila Parishad, subject post facto approval to the appointment of Buddheshwar Roy. Because the Jila Parishad time to time forwarded and requested for approval to the state government. So, in response to that, this letter was this that the following documents be furnished to the government: copy of service book, copy of resolution, copy of GO number 988 again, and copy of memo number of 2011 and other relevant papers for proper appreciation of the case. Naturally, they wanted some papers, otherwise it is not possible. Now, Lordship, kindly come to page number 72. That is, my lord, one of the impugned letter and or communication which has been, my lord, assailed in this proceeding. Page number 72. Have you also got it, my lord? Now, my lord, first very vital point and or facts are that it was updated 25th of February 2016. And from Joint Secretary to the Government of West Bengal to the Additional Executive Officer, Bardhaman Jila Parishad. Post facto approval was the caption or subject matter, and then undersigned is directed to refer to his office memo number such and such, dated 12 February 2013 on the subject noted above, and to say that the matter was moved with the Finance Department for consideration. The undersigned would like to inform that the Finance Department have conveyed their inability to agree to regularize the said absorption as the assistant cashier is not a feeder post of sub-assistant engineer.
Yes.
Only point, explain, that is, suffice to say that why you are not eligible for the post, so your I think a prayer for regularization cannot be agreed upon. One line, one sentence sufficient. It suffices to say that because your assistant cashier post from 2003, which you accepted and joined, it was not the feeder post of this sub-assistant engineer. So when it was offered to you in 2007, and maybe still you are in charge of that and you are still there, but we are unable because that was illegal and we cannot do stamp on that illegal appointment.
Yes.
Then he further challenged, that is the another order of 2016, because 2013 was the order of the state government through Finance Department, and in 2000 I think it of the 22 to 23 page 21, another order, it is also under challenge, but it is consequential because this order was issued by Executive Officer Purbo Bardhaman Jila Parishad. Page 82. Page 82. It is also under challenge. Two orders are under challenge. First is of 2016. Second is of this, I think, 2022. 2023. This is consequential because of the fact he was asked to revert it to his earlier post of cashier because the state government did not agree or they had rejected your prayer. So no question of occupying that sub-assistant engineer. You are no more sub-assistant engineer. So you go back to your original post of assistant cashier. This was the order. I can say, rather we can say it is consequential. There was no other, my lord, the option. Because the main order was of 2016 when the state government finally rejected. That no, it is not possible. Now, at this juncture, my lord, so my lord, at this juncture, my lord, there are 3 or 4 points on our stand. First is that delay defeats equity. 2016, it was the order passed by the government rejected. There is no averment in the writ petition. It was not in my knowledge. No averment in the writ petition that it was not in the knowledge of the petitioner, or when it came to his knowledge for the first time. But normally, my lord, when we write it, we have to say that when it comes to my knowledge for the first time, there is no such averment. So it is presumed that immediately after, in 2016, it was in his knowledge. Retired in 2025 or 2023. And the writ petition filed in 2024. I see. 31st March 2025. On the verge of his retirement, he filed this writ petition in 2024. And that it appears that it was affirmed on yes, almost at the end of the year 2024. Naturally, in January 31st, it was the date of his retirement or superannuation. Immediately prior to that, preceding 1 or 2 months back, filed the writ petition. From 2016 to 2014 end, it took almost about 8 years to file the writ petition to ventilate his grievance before the writ court. Now, my lord, my humble submission is that a person who sat on fencing and said on the verge of retirement, this is my right arising out of my employment, well, no relief should be granted to him because of there are category of decisions. I rely only 1 or 2 decisions. Well, this is my lord 2015 Volume 15 SCC. And my lord, the relevant paragraph.
Which number আছে?
Yes, page 1.
Page কত?
Page 1. 2015 Volume 15 SCC, page 1. Now, my lord, kindly come to para 37 onwards. Para 37 onwards. There were some other issues cropped up therein. We are not, my lord, concerned about the same. So better, my lord, straightway come to paragraph number 37. Reported judgment এ কপি দিতে হয়? আমি কোথাও পড়িনি, শিখে আসছি।
Yes.
Now, my lord, paragraph 37. Let us examine the matter from another aspect, namely laches and delays and acquiescence. It is now a well-recognized principle of jurisprudence that a right not exercised for a long time is non-existent, even when there is no limitation period prescribed by any statute relating to certain proceedings. In such cases, courts have coined the doctrine of laches and delays, as well as doctrine of acquiescence, and non-suited the litigant to approach the court belatedly without any justifiable explanation for bringing the action after unreasonable delay. Doctrine of laches is in fact an application of maxim of equity. Delay defeats equity. This principle is applied in those cases where discretionary orders of the court are claimed, such as specific performance, permanent or temporary injunction, appointment of receiver. Then These principles are also applied in the writ petition filed under Article 32 and 226 of the Constitution of India. In such cases, courts can still refuse relief where the delay on the petitioner's part has prejudiced the respondent, even though the petitioner might have come to court within the period prescribed by Limitation Act. Then again, Lordship, kindly come to my lord, page number 40, paragraph 40. Likewise, if a party having a right stands by and sees another acting in a manner inconsistent with that right and makes no objection while the act is in progress, he cannot afterwards complain. This principle is based on the doctrine of acquiescence, implying that in such a case, the party who did not make any objection acquiesced into the alleged wrongful act of the other party and therefore has no right to complain against the alleged wrong. This has happened here. It is, my lord, applicable in this case also. Then, my lord, another judgment is, my lord, I rely upon 2022 SCC, volume 2, page 25. Let to be. (2022) volume 2 SCC, page 25. Now, my lord, the relevant paragraphs are 20 onwards. 4 or 5 paragraphs. I would draw your lordship's kind attention. My lord, paragraph number 20. Here also, my lord, several issues were there, but the so far these paragraphs are concerned with regard to delay, laches, acquisitions. Paragraph 20. Have you noted? The principles governing delay, laches, and acquisitions are overlapping and interconnected on many occasions. However, because kindly may I pause here? Yes, delay, laches, acquisitions, they are all interconnected. The grade of delay, the time of how, and all connected, including the laches. However, they have their distinct characters and distinct elements. One can say that delay is the genus to which laches and acquiescence are species. Similarly, laches might be called a genus to a species by name acquiescence. However, there may be a case where acquiescence is involved but not laches. This principle, here it is not. Here laches, delay, acquiescence, all, my lord, are, my lord, present. These principles are common law principles, and perhaps one could identify that these principles find place in various statutes which restrict the period of limitation and create non-consideration of condonation in certain circumstances. They are bound to be applied by way of practice requiring prudence of the court than of a strict application of law. Underlying principle governing this concept would be one of estoppel. They are stopped from raising their grievance any further. The question of prejudice is also an important issue to be taken note by the court. Then, my lord, the laches, it is stated there in paragraph 21, the word laches is derived from the French. My lord, may I just skip it? Then, my lord, 22, 23. Skip over, then 22. Yes, 22. Two essential factors to be seen are the length of the delay and the nature of acts done during the interval. Here, my lord, almost 8 years or more than 8 years. Length of delay. As stated, it would also involve acquiescence on the part of the party approaching the court apart from change in position in the interregnum. May not be change in position, but delay is there. Therefore, it would be unjustifiable for a court of equity, because writ court is a court of equity, court of equity, to confer a remedy on a party who knocks its doors on when his acts would indicate a waiver of such a right. My humble submission, yes, his conduct, it shows waiver of his right. So, court of equity should not, my lord, pass any order in his favor. By his conduct, he has put the other party in a particular position. Here may not be that stage, other party in particular, but here may not be. But still, the delay and the latches, everything is there. Thus, a man responsible for his conduct on equity is not expected to be allowed to avail a remedy. This is very vital, the last sentence of paragraph number 22. Thus, a man responsible for his conduct on equity is not expected to be allowed to avail a remedy.
Yes.
So, my lord, there is no need to, my lord, read any further, my lord, these the subsequent paragraph 24 and 25 acquiescence. But I think it is, my lord, it is sufficient so far these paragraphs are concerned, so far my stand is concerned, or this point is concerned. Then, my lord, another point is estoppel. They may say that now you are stopped from taking any further point. Because you have given my appointment, I have acted upon for long period from 2007 to 2016 when it was rejected with regard to my approval. So I have acted upon, I have changed my position. So that means it's a case of estoppel. My humble submission is that it's a well-settled law, no estoppel against the statute. There cannot be any estoppel against the statute. Statute means here the recruitment rules. Statute means here the recruitment rules. It may be subordinate legislation, but still it's a rule and it's a statute. Now, my lord, only one judgment, my lord, sufficed, my lord, to my point, that is 2013, volume 5, SCC 427.
Yes. Which paragraph?
Well, paragraph 34. But sometimes one or more two sentences from the Supreme Court or Apex Court or even from our court also, my lord, that is sufficient to explain that actually what is the law. There may not be any requirement to read any further. Then lordship kindly come to paragraph 34. Be that as it may, there can be no estoppel against the law or public policy. The state and statutory authorities are not bound by their previous erroneous understanding or interpretation of law. Statutory authorities or legislature cannot be asked to act in contravention of law. Sometimes, my lord, 2 or 3 sentences are sufficient that what fell from their lordships or what fell from your lordships, that what should be the law, what is the law. Because the statute I have to follow. Even if there was, my lord, any earlier conduct act on behalf of any officer, on behalf of the authority, you may say that he had the authority. He may have had the authority. But still, if it was contrary to law, then whatever you have acted, you enjoyed, that's sufficient. But you cannot say that on the basis of that, a further benefit should be on you. That is the permanency. That is, my lord, that is the regularization. No, it cannot be. It cannot be. And that is exactly what has been done here, that no regularization, because your initial appointment, your initial entry point, that was illegal. কি করবে শেষ করে যাবে Darshik, kindly paragraph 34, my lord, there is an, my lord, internal, my lord, paragraph that is, my lord, quoted herein. Once more, if your lordship kindly, my lord, come to the statutory body cannot be stopped from denying that it has entered into a contract which it was ultra virus for it to make. No corporate body can be bound by estoppel to do something beyond its powers or to refrain from doing what it is duty to do. And that is estoppel. No estoppel. Then, my lord, one more is that he can say that it's a case of promissory estoppel. There was a promise from the Jila Parishad by way of regular way, sending one after another recommendation or prayer or representation in his favor to the government for regularization, because they have done it. So he may say that, yes, it's a case of estoppel, promissory estoppel. I think there was a promise floated and I have accepted that promise. Then, my lord, there are so many judgments on this court, but I rely upon, I think, my lord, if one judgment sufficient for that score, then that is sufficient. No need to, my lord, burden your lordship by, my lord, the more than one judgment. My lord, it is, my lord, 2012, volume 4 SCC, 2012, volume 4 SCC, page 441. And that is, my lord, on the legal point that promissory estoppel cannot be invoked.
Each paragraph number.
My lord, yes, my lord, paragraph 6, 7, 8, 12 onwards. There are 6 or 7 paragraphs. I am coming. Better, lordship, kindly come to straightway. Paragraph number 15, lordship, kindly come to. 15, lordship. Have you lordship got it, my lord? In Union of India versus Godfrey Phillips India Limited, a 3-judge bench of this court has crystallized the principle that there can be no promissory estoppel against the legislature in the exercise of its legislative function, nor can the government or public authority be debarred by promissory estoppel from enforcing a statutory prohibition. It is equally true that promissory estoppel cannot be used to compel the government or a public authority to carry out a representation or promise which is contrary to law or which was outside the authority or power of the officer of the government or of the public authority to make. Jila Parishad is the public authority. Beyond this power, to, my lord, giving that appointment to that post of sub-assistant engineer, indicating that by way of promotion, by divorcing the rules. So no promissory estoppel. Then next, para 16, in Ashok Kumar Maheshwari versus State of UP, this principle was reiterated in Union of India versus Arshide Souja, where a retired army officer was recruited as assistant commandant on temporary basis was called upon to exercise his option for regularization contrary to the statutory rules, it was held that it would not amount to estoppel against the department. And eventually at paragraph 38, in that case, the appeal filed by State of Kerala were allowed, order passed in the writ appeal and the application for review being unsustainable, set aside. The state government functionaries are at liberty to proceed against the first respondent for his eviction. Then, my lord, another question remains with regard to their claim for regularization.
Yes.
So now the only point remains, I have to urge on that, my lord, the point of regularization. It was their claim, regularization, approval and regularization, post facto approval, as well as the other side of the coin is that regularization. Now, Lordship, kindly, my lord, I rely upon so many judgments are there with regard to regularization. Even after Uma Devi, till date, so many judgments. But may I just tell you, for your lordship, that in most of the judgments, there, my lord, the facts were that with regard to some casual or temporary workers engaged by the entity, and after some time, suppose 10 years, 12 years, 15 years, my lord, all those casual or, my lord, temporary employees, they claim for regularization. And in Uma Devi said that, first of all, there should be a scheme. Uma Devi has never said each and everybody should be regularized their services. No. Uma Devi said, first of all, there should not be any illegal appointment. When there is illegal appointment, then no benefit should be in their favor. If irregular, then to some extent benefit that regarding that scheme should be floated by the state government. Scheme means that, my lord, whatever your post sanction or you create the post either at one go or phase wise, that is the scheme. But so far this point is concerned, this is not with regard to, my lord, that casual or temporary. This is with regard to the, my lord, a particular person was given appointment to the post on promotion who was not supposed to give promotion to that post because of not holding immediate feeder post. Now, in 2007, volume 1 SCC 575, my lord, I rely upon this. 2007, volume 1 SCC 575.
Yes.
Paragraph 10, paragraph 12, paragraph 17. Kindly come to, my lord, paragraph 10. The respondent was also not appointed in terms of the statutory rules. He was furthermore not entitled to any regular scale of pay attached to any post. Therefore, he could not have been directed to be regularized in service, having regard to the Constitution Bench decision of this court in State of Karnataka versus Umadevi. Reliance, however, has been played by Mr. Mathur on para 53 of the judgment, which reads as under. Naturally, my lord, the learned advocate who appeared on behalf of the respondent, he referred that Umadevi judgment, and my lord, everybody, my lord, referred that para 53, where, my lord, the distinction carved out with regard to that, my lord, the legality and some irregular appointment. Then, my lord, kindly come to paragraph 12. Paragraph 12. The question which thus arises for consideration would be, is there any distinction between irregular appointment and illegal appointment? The distinction between the two terms is apparent. In the event the appointment is made in total disregard of the constitutional scheme, as also the recruitment rules framed by the employer, which is the state, within the meaning of Article 12 of the Constitution of India, the recruitment would be an illegal one. Whereas there may be cases where, although substantial compliance with the constitutional scheme as also the rules have been made, the appointment may be irregular in the sense that some provisions of some rules might not have been strictly adhered to. Very clear.
Yes.
Illegal and irregular, very clear, the distinction. The expression illegal said that if appointment was made, dehodes the rules, the law, then illegal. So, my lord, my humble submission is this, that the rejection done in 2016 with regard to the prayer for regularization and or, my lord, the post facto approval of the state government to the said appointment of sub-assistant engineer by the Jela Parishad, well, that was rightly done. Number one, that was rightly done. Number two, the writ petition itself, my lord, is not, my lord, maintained. I cannot say maintainable, but it is not sustainable. Because maintainable is something different. Suppose there is alternative remedy, I have taken that point, or otherwise. No, I am not saying maintainable, but not sustainable in law because of the court of equity. He has missed the bus because he has not come in a right time with the right approach before the court.
Any other point?
But that's
Mr. Keshav? Heard Mr. Amol Sen, learned additional government leader.
my lord, additional
advocate আজকে কিন্তু বেশ আজকে বুধবার হ্যাঁ
Thanks, Pardon. Additional Advocate General to conclude his argument.
বলুন তাড়াতাড়ি
Any reply to be made?
Next, any day convenient to end up.
next week Wednesday
The other aspect which you have not argued, they have harped on a point that though the order was passed stating promotion, but subsequently a resolution has been taken by the Jila Parishad holding it to be an absorption to the post. How the circumstances changes, this has not been argued by you.
very sorry,
If
my lord.
if
I
it
did
is,
not,
if
I
the
did
order
not
says
take-
promotion
I did
and
not take note
subsequent
of.
resolution says absorption, how the circumstances changes in case of the petition?
My lord, the answer to this is that whatever, my lord, the consideration they, my lord, had taken at the time of initial appointment to that on promotion, my lord, that cannot be, my lord, because that would remains, because the decision-making process kindly consider one thing. The decision-making process already, my lord, took place on that day when that decision was taken in 2007 by the Jela Parishad in its meeting. That decision-making process there cannot be any review. There cannot be any review. My lord knows that the executive has no power to review its own decision unless the statute provide that. It's also a settled law. It is also a settled law.
Okay.
That executive cannot review its own decision or amend unless it is provided under the statute.
What's his argument? Reply next week.
Next week.
Return.
On
Next
13th,
Wednesday,
next Wednesday. At the top.
13th.
Top one.
at the top,
Top one.
at the top 3.
I shall try. I don't know what is your serial number coming at 13th.
Let it be top one.
Top
Oh,
1.
top one.
Get
Okay, thank you. এগুলোকে compile করে
The 4 p.m. matter. Of course, it can't be taken up today. Kindly be pleased to fix it any day, perhaps at 3:30.
But that has to be resolved first, that whether this is document scanned copy of those documents. If it is,
Your Lordship has heard my learned friend on that. Kindly allow me only 10 minutes on a given day, only on this aspect.
So I have little to submit. Also, I will submit two more. I will show your lordship two documents from the petition itself.
no, yesterday he also said, and I also asked you whether there is any relevancy of those documents. Because it does not mean each and every document.
Exactly.
I will satisfy my lord. Kindly fixable and
in terms of the players, it is a restriction that is certiorari, without certiorari. My learned friend is entitled to have the document if the court directs. Now, here the honorable court has directed IOC to produce the documents. Now, according to IOCL, they have got some of, say there are 10 documents. Out of those, they have 7 original, and these scanned copies of original are not available according to them. Good, but that is the submission I could understand. Now, if it is and now it is for your lordship to decide whether to accept this document or to pass any order on the basis of considering those documents or not. Now, I understand that my direct sale on behalf of IOC close their points that they have no more anything to produce before your lordship. And on the basis of that, my lord take a call, considering the other portion of the payment. Now, if your lordship kindly permit us, none of us will make more time. My lordship will also will just make a reply. If required, then I will reply only.
No, my lord.
Only to the new points, if any.
Then I'll take no new points. I'll confine myself.
I will take only 10 minutes, your lordship. I will take only 10 minutes to show this.
Kindly permits us to come back any day subject to my lord's convenience at 2 p.m. or 10:30. Your lordship.
10:30.
10:30 is being very optimistic, my lord. I understand your lordship's roster is very heavy. My lord, any day in the second half, as per my lord's convenience.
Will not take more than half an hour. I understand from all of our sides.
My lord, also, my lord, the extra documents that he wishes to, my lord, place on record, at least let him give me a copy so that I could, my lord, say some.
You have to concede to that. These are the relevant documents. We'll take with the certification of the authority on that document. Yesterday, I also told you, you cannot give a scanned copy that this is scanned of the original.
My lord,
somebody has to certify that this is the original document.
But my lord, unless I see what they want to show, my lord, how do I comment on the, my lord, relevance of the document? Whether it's form.
Those are
let him produce those documents on the next day.
They have produced the records. I have been given a copy of the records.
That scanned copy also.
Very well.
On that day, you go through the document. I'm not asking you to hand over a copy right now.
Very well. Very well. Very well, my lord.
Thereafter, I will ask him to, because I have gone through that document, there is no certification of the authority. So for the authenticity of that document, some certification is required from the authority. So after you go through the document, make your submissions. Yes, correctly.
Lordship, kindly fix it. Lordship, kindly fix it any day in the next week. In the meantime, I will get certification done.
Follow. In the on the and prayers of the parties list this matter on দেখে বলো মানে আসবে তারপরে হচ্ছে না মানে একটু দেখি তো এগোতে হবে একটু ফাঁকাই থাক না যেখানে অ্যাসাইন ম্যাটারটা ফোর্থ রিটার্নেবল থাকবেই 12th দেবো 12th দেবো 12th দিই 4 PM 12 তারিখ কি বার
My lord. Who wants him kindly, my lord?
PM is difficult
Bad request, we understand, but
we will
my lord, we appreciate.
correct August 12th তো মঙ্গলবার কিন্তু 24-এর মোশন Okay, I'll take it up on 4 PM.
Very good.
At 4 PM.
I'll not make you wait because every day you are coming with that is also
My lord, I will at 4 PM, my lord, I will just come and stand behind the arguing lawyer so that your lordship can see me and remember.
Lordship is to release all matters. I mentioned,
I could not.
at 4 PM.
Lordship is
Tuesday
to
we will
release all
stop every
matter. I
matter and
mentioned,
take it.
Your Lordship.
4 PM, not 12.
4 PM.
Great.
After the returnable motion, I will take it.
Grateful.
I'm grateful.
Thank you, sir.
Hey, brother.